morning, everyone. Welcome to the Junior Scholar Symposium on Public International Law. This is the 5th edition of our symposium and our first time to do it in person. Today is special because we have not only students from UP College of Law in the Juris Doctor program, we will also be joined by our Master of Laws students. And most importantly, we are joined by fellows. These are law teachers, these are lawyers teaching international law who are enrolled in the fellowship course on effective teaching methods of international law organized by the Legal Education Advancement Program. So 3 groups: LEAP fellows, they'll go first, and then we'll have our J.D. students, and then we'll have our LL.M. students tomorrow. We have 11 presenters from the LEAP fellows. We have, I think, almost 50 from the Juris Doctor students and 25 from the Master of Law students. Our event partners are the Legal Education Board, the Integrated Bar of the Philippines, the Philippine Society of International Law, and the Philippine Association of Law Schools. Last year, and hopefully they can still join us today in this event, is the Philippine Judicial Academy, which was our event partner in previous symposia. Okay? So the symposium will involve a presentation of the case studies of our LEAP fellows, our J.D. students, and our LL.M. students. And their case studies have one aim, and that aim is to show that international law, as well as ASEAN law, which is a kind of international law, can be applied in Philippine cases. Cases, dualist view. Okay? Instead, in the Philippines, we follow the dualist view. The view that the international legal system is separate, apart, and distinct from the national legal system. Okay? So rules of international law exist only in the international legal system. They are created there, they are enforced there, they are interpreted there in that legal system. And that legal system is separate from ours. We create rules in the Philippine legal system, we interpret them in the Philippine legal system, and we apply them here. However, there are ways by which rules of international law, which exist in the international legal system, somehow find their way in the Philippine legal system. Somehow they are domesticated. And the ways by which they are domesticated are those prescribed by the Philippine Constitution. In terms of customary rules, they are domesticated through incorporation, in the incorporation clause. If they are international agreements, they are domesticated through transformation. Okay? Now, how can we apply rules of international law in a Philippine case? I have proposed a 7-step process for analyzing how rules of international law can be applied in a Philippine case. We begin with step 1. We ask whether the rule that we want to invoke is a binding rule of international law. We have to be careful because in the international legal system, there are many legal instruments, many of them consisting of soft law, not binding. Okay? So we may be tricked into invoking soft law instrument, which actually is not binding. Example, the Universal Declaration of Human Rights. Actually, it's not binding. What is binding would be the unwritten customary rules reflected in the UDHR. Okay, so make sure that we are invoking a binding rule, not soft law. Okay? Second, we have to identify the manner by which the rule that we want to apply was created in the international legal system. And there are only 3 ways: by international agreement, by customary law, or by deriving general principles of law from the national legal systems. Why is so for step 2, we identify the manner by which it was created. It's also called the formal source. Okay? In step 2, we should also identify the evidence of the existence of the rule and of its content, what it provides and prohibits. This is what we call the material source. So for the international agreement, it's the text of the agreement itself. Okay? In step 3, now we know that in step 1, the rule that we want to apply is binding on states in general. But for step 3, we ask a more specific question. We ask whether the rule is binding on the Philippines or we are not bound by the regional customary rule. So it's possible we're not bound by it. So for step 3, make sure that the Philippines is bound. If we want to invoke an international agreement, it's very easy. We just go to the website, check whether the Philippines is a party. Philippines will be a party if the Philippines expressed its consent to be bound by the agreement in the prescribed way, as prescribed in the agreement. Okay? Now, after we do steps 1, 2, and 3, which require us to have some basic knowledge of international law, okay, we'll now have to cross this international date line, this solid line. We move from the green arrow to the maroon arrow. So we cross this line and we move to the Philippine legal system. So for steps 4, 5, 6, and 7, we are asking Philippine law questions, which should be easy for us as students of Philippine law and as also practitioners of Philippine law. So our first Philippine law question would be, has the rule of international law been domesticated? Is it now a Philippine legal rule? And as such, has it created Philippine legal rights and Philippine legal obligations? Okay. So as we said, step 4 is determined by step 2. If it's an international agreement, the rule of international law will be domesticated by transformation. If it's a customary rule, it will be domesticated through incorporation. Okay? Next, now that we know that it is part of Philippine law, it is now a Philippine legal rule. What is its place in the Philippine legal hierarchy? We know that in the Philippine legal system, there is a hierarchy of rules. On the top tier, we have the constitutional provisions. Second tier, we have statutes and similar instruments. On the third tier, we have executive regulations, procedural rules, and local ordinances. So where do we put this domesticated rule of international law? If it's an international agreement, it depends. If it's considered a treaty under Philippine law, then it's on the same level as statute. If it is a mere executive agreement, then it's on the third tier, same level as executive regulations only. If it's an unwritten customary rule, which has been incorporated as part of the law of the land, it's on the same level as statutes. Okay? Then we go to step 6. We ask ourselves, what is the effect of our domesticated rule of international law on Philippine legal rules that came from domestic sources? What are these Philippine legal rules which came from domestic sources? They are consti provisions, statutes, executive regulations, procedural rules, and also local ordinances. Okay? So there are 3 possible effects. The first possible effect is that there is a gap in Philippine law, and this domesticated international rule will fill the gap. Second possibility is that it will result in a reinterpretation of the domestic rule. So there's no amendment of the rule, there's no change in the text of the rule. What changed will be the interpretation. Okay? The third possible effect is that it will conflict with an existing domestic rule. Now, if there's a conflict, the Supreme Court has said, we resolve the conflict between a rule of international law and a rule of Philippine law, regardless of its nature, whether it's a consti provision, statute, executive regulation, procedural rule, or ordinance. We resolve it by applying principles of statutory interpretation, Statcon principles, which may sound weird because we should apply Statcon principles only when interpreting statutes, right? But Supreme Court said no. Whatever the kind of Philippine legal rule, we can apply those Statcon rules. And there are 3. As I explained in my sequential analysis, the principle of lex superior, the rule which is superior in nature will prevail if there's a conflict. Second is lex specialis. In case they are on the same level, it's a rule which is more specific which will prevail. And the third would be the principle of lex posterior. So if they're on the same level, they have the same degree of specificity, the rule which came later in time will prevail. Now, we can't just apply the Statcon principles any way we please. We have to apply them in the proper sequence. Okay? That's why we call it sequential analysis. Now, after we've done the analysis on the effect of the domesticated international rule on Philippine legal rules, then we can apply the international rule in the Philippine case. And there are 4 possible outcomes. We can use the rule of international law to prohibit an act which we don't want done. Second, we can use the rule of international law to compel the performance of a legal duty arising from that domesticated international rule. Number 3, we can use the rule to authorize our client to perform an act which previously was prohibited or not expressly authorized. And finally, we can use the domesticated international rule to declare the legal status of a person or an act. With regard to the person, status of a person, this was done by the Supreme Court in the case of Senator Grace Poe. They declared her a natural-born Filipino, right? In the case of an act, we can see the example of DFA versus NLRC, where the Supreme Court invalidated the labor arbiter's decision. They declared it invalid for violating a domesticated rule of international law. So this is a summary of the 7-step process applied by our LEAF fellows and also by our J.D. students and our LL.M. students. A final note before I turn over the floor to our first LEAP presenter. So this symposium and also the approach, the 7-step process, these are really products of the pandemic. We had classes in March 2020 in person, and then those in-person classes were canceled. We had to shift to online. When first semester started, we were wondering about the class activities, learning activities for students and how to do their assessment. That's where I got the idea of doing deep learning for the students, individualized case studies, which is a lot of work for the student and also for the supervisor, for myself also, because I have to supervise each of the papers. But I'm very happy with the outcome, because at the end of the day, what I hope is that students will not just have knowledge of international law, but actual skills they can use in their law practice. Also, the approach, the 7-step process, has been percolating for many years. In 2019, I had a version of this, a 5-step process, and then became 6 steps. And then during the pandemic, when there was, we were all stuck at home, we had time to write. And so now it's this 7-step process. So, so some good things are produced by isolation. Okay, so I will now invite our LEAP fellows. Maybe very briefly, I will introduce them. No? So we'll have this order. I'm not sure if Attorney Miller Quintin is available. He'll be joining us online. I'm not sure if he's available. Is he there already? He's there. Okay, so first we'll have Attorney Quintin. Attorney Miller Quintin Jr. He is based in Baguio City, right? Baguio City. And then we have Attorney Nico Aguilar, also from Baguio. Oh, Baguio is well represented. Huh? Teaching, no? Also teaching J.D., the J.D. program. And then we have Attorney Anton Avila, fresh from the plane, who is also teaching, right? You're teaching the J.D. program? Yes, okay, thank you. And then I'm not sure if the next presenter can join us online. Attorney Gary Villarreal, is he there? Attorney Gary Villarreal is available. And then we have a UP Law alumni, class 2019, Mutter, who is here with us in person, Attorney Marian Betug. And then we have from West Visayas State University Law School, from Iloilo, but studied here in nearby law school. Attorney Carl Mondihar, okay, from Iloilo. And then we have a dean, dean of San Sebastian, right? San Sebastian Graduate School of Law. I'm also proud to say that he is a fellow Ilonggo also. Dami na po-produce ng Iloilo. Si Dean Rodel Taton, okay? And then a graduate also of UP College of Law, now a part of the UP Law faculty in the J.D. program, no? In Diliman and in BGC. Si Attorney Jox Dilag. Yan. And then we have a sitting judge. So you have to sit properly, you have to maybe stand when he presents. Si Judge Jose Kimbo from Bataan, sir, no? Bataan, yes. Okay. So I'll now invite our first presenter. So we'll have three presenters first, no? So Attorney Quintin, Attorney Aguilar, and Attorney Avila. And then if we have time, we can ask them a few questions. Okay?
Good morning. I am Attorney Miller Quintin Jr., based here in Latvia, Benguet, and just adjacent to the city of Baguio. Our topic here is, or the international agreement that is the center of our study is the Vienna Convention on Road Signs and Signals of 1968. Okay, the Philippines is an original signatory to the convention, and it has become actually a part of the law of the land by the principle of transformation by virtue of Presidential Decree number 207, series of 1973, promulgated on June 6, 1973. And relevant to the decree states that by virtue of the law, the President hereby adopts and makes as part of the law of the land the 1968 Vienna Convention on Road Traffic and Road Signs and Signals. Now, the current laws that we have here is, of course, PD 207. We have traffic rules, Republic Act number 4163, the Land Transportation and Traffic Code. However, this particular law does not specify any standard signs and signals. And the DPWH came up with the Highway Safety Design Standards on road signs. The problem with this is that I think it is only binding with the DPWH, and it does not bind the local government units or other government agencies. Now, the Vienna Convention on Road Signs and Signals contain rules for international uniformity of road signs, signals, and symbols and markings. And the problem that we wish to address with the here is the gap in our local laws where local government units come up with their own road signs. They have, and even local government units accepting donations from corporations where they post advertisements in these road signs. Now, of course, with these different kinds of road signs in our jurisdiction, it may cause confusion and it may cause also um, accidents when these road signs are not properly identified. Now, it fills that particular gap. It can be used. Now, the convention can be used to compel these local government units to take down these road signs and to put up road signs that are compliant with our obligations under international law. Similarly, persons who have been charged with violation of local ordinances where the ordinance would state that it is punishable if they did not comply with these road signs and traffic signals. It can be used as a defense, stating that these are not road signs, these are not road signals, as they are not compliant with international standards. So as I mentioned, no, there is no local law. There is no statute which provides for these particular standards. And with the help of this international convention, it fills a gap in our local rules. No, thank you.
Hello, good morning. My name is Eric Carl Nicolas Aguilar from St. Louis University. Um, my topic will be about red tagging. This is something which is very relevant right now. This is something that we always wanted to avoid, especially in the fight or in the pursuit of our democratic rights. The Philippine situation with the CPP, NPA, NDF may be categorized or may be classified as a non-international armed conflict pursuant to the definitions under Common Article 3 of the Geneva Conventions and Article 1 of Additional Protocol 2, and applying the intensity and organization tests as laid down by the International Criminal Tribunal of the former Yugoslavia in Prosecutor versus Tadic, as affirmed by the subsequent cases from the International Criminal Court in Prosecutor versus Lubanga and Prosecutor versus Katanga. We can classify the situation of the government of the Republic of the Philippines and the CPP-NPA as one which is a non-international armed conflict, thereby calling for the application of principles of international humanitarian law, especially those contained in the Geneva Conventions and its additional protocols. In fact, the Philippines and the government of the Philippines and the National Democratic Front created a document which tried to settle or which tried to agree upon certain terms and conditions pertaining to the respect of human rights. And this document is called the Comprehensive Agreement for the Respect of Human Rights and International Humanitarian Law, otherwise known as the CARIL. Despite these documents, we see that red tagging is still rampant. And we think that there has to be a shift in viewing red tagging as a wartime offense, precisely because the problem of red tagging stems from the very existence of a non-international armed conflict between the Philippine government and the CPP, NPA, NDF. Justice Leonen, in his dissenting opinion in Aquino versus Zarate versus Aquino, defined red tagging as the act of labeling, branding, naming and accusing individuals and or organizations of being left-leaning, subversives, communists, or terrorists as a strategy by state agents, particularly law enforcement agencies and the military. So the relief sought in this particular study is to prohibit the Philippine government from engaging in acts of red tagging. What do we mean when we say prohibit the Philippine government? This could mean, for example, that probably an injunction will lie to restrain a certain military official from tagging members of progressive groups or even progressive groups themselves, from tagging them as part of the CPP, NPA, NDF. What is the PIL rule I'm invoking in this study? This is the customary international humanitarian law of the principle of distinction, which basically means that in times of armed conflict, there has to be a distinction between combatants and civilians, and that civilians are not to be considered as military objectives and hence not subject to attack, because attacks may only be directed against combatants. This customary international humanitarian law on the principle of distinction is reflected under Additional Protocol 2 of the Geneva Conventions, particularly in Article 4, which basically provides for the rights of civilians under a non-international armed conflict, which includes the obligation of both parties to prevent any threats to civilian populations, threats such as murder or any threat against their dignity as a people. And the source of this particular rule in international law is, of course, is customary international law, and the material source is the reflection of the customary international law in Additional Protocol 2 of the Geneva Conventions. Why is the Philippines bound by this rule of international law? The Philippines ratified Additional Protocol 2 of the Geneva Conventions on December 12, 1986. This rule has been domesticated, number one, via incorporation, because this is a customary international law. And its reflection, Additional Protocol 2, we can consider it as having been domesticated via transformation, especially when the Philippine Congress passed Republic Act 9851, which is a domestic law punishing crimes against humanity and punishing war crimes pursuant to the Geneva Conventions. The place of this rule in the Philippine hierarchy is it's a statute, and the concerned Philippine rule in this particular case is a particular provision in RA 9851. Section 15 in RA 9851 provides that when the courts apply this particular law in its judicial decisions, they have to be guided by certain international law provisions. And among them is of additional protocol 2 of the Geneva Conventions. How do we then analyze, is this sufficient enough? I think that there is a gap with RA 9851. Number one, because there is no express recognition that that red tagging is an offense. That's first. And second, the law never really mentioned about this concept in the first place. And that's why, in addressing this particular issue, it's either we see this as a gap in existing Philippine rule, or it's either we can also look at it as a way of reframing how we take a look at these kinds of red tagging as a phenomenon. That's why, I think that an application of this customary international humanitarian law and the application of additional protocol 2 will eventually justify a relief of prohibiting Philippine government officials from red tagging, precisely because in the personal field of application of international humanitarian law, this is applicable because the Philippines is under a non-international armed conflict, and because this rule has already been domesticated under the Philippine legal system, and hence I think that this rule can be used to enjoin government officials from never committing red tagging again. Thank you.
Sorry, ang tangkad ni Nico. Good morning, everyone. My name is Anton Luis Avila, and I will be talking about the ICCPR as basis to raise the exclusionary rule to exclude evidence obtained from privacy rights violations committed by non-state actors. Current constitutional doctrines provide that any evidence obtained by non-state agents in violations of the Bill of Rights, including the right to privacy, will not be considered the fruit of the poisonous tree and is thus admissible in evidence. It would seem that there is an exception to this, as held in the case of Zulueta, where the court held proper the exclusion of the evidence obtained by the wife in violation of the husband's right to privacy. However, the Supreme Court en banc in Cadajas has finally settled the issue and ruled that the discussions in Zulueta are mere obiter dictum. Thus, the doctrine stands that the Bill of Rights can only be invoked against state agents. It is evident that the Bill of Rights is a reflection of human rights, and Congress has deemed it fit to include certain human rights violations as a basis to exclude evidence, regardless if committed by state agents or private actors. One of which is the Anti-Torture Act of 2009, which holds that evidence obtained as a result of torture shall be inadmissible in any proceedings. On the other hand, although violations of the right to privacy committed by private individuals may still be punished with civil, criminal, or administrative liabilities, there are no corresponding laws or rules to render evidence inadmissible for such a violation. The International Covenant on Civil and Political Rights, or the ICCPR, imposes liberty-oriented obligations upon the state, owing to its citizens. Unlike the Bill of Rights under the 1987 Constitution, which imposes only negative obligations upon the state, the obligations to respect human rights. The ICCPR imposes positive and negative obligations upon the signatory states. The obligation to respect, protect, and fulfill human rights. These obligations will only be fully discharged if individuals are protected by the state, not just against violations of covenant rights by state agents, but also against acts committed by private persons. The ICCPR mandates the signatory states to take the necessary steps to provide effective remedies, which may be in the form of legislative, administrative, educative, and certainly judicial measures. The ICCPR was domesticated through transformation. The Philippines signed the treaty on December 19, 1966, and it was ratified by the President on February 23, 1986, during the interregnum. Thus, the ICCPR has the force and effect of law under our jurisdiction and can be used as legal basis to exclude evidence obtained by non-state agents in violations of the right to privacy. The exclusion under the ICCPR will not be in conflict with established jurisprudence. The doctrine that the Bill of Rights can only be invoked against state agents will still hold true, but the ICCPR can fill the gap by excluding evidence obtained by non-state agents in violation of privacy rights. For sure, there are many scenarios where it may be deemed appropriate to exclude evidence for such a violation. Such procedural rule should not, however, turn its head away from the balancing the interests of substantial justice and procedural rules, such as in the case of Kadahas, where the privacy rights of the accused yielded to the greater good of criminal responsibility. In sum, as the Philippines is bound to respect, protect, and fulfill the privacy rights of its citizens, the ICCPR can be used as a legal basis to allow the court to apply the doctrine of the fruit of the poisonous tree and exclude evidence obtained by non-state agents in violating the right to privacy. Thank you so much for listening.
I think we have time to ask a few questions. So we have a question to Attorney Quintin. Is Attorney Miller there? Is he there? Yeah, can we go back to his slide, please? The first one. Yes, okay. So questions for Attorney Quintin, right? Can you please clarify how the international rule that you want to use in this case was domesticated? Was it domesticated by presidential ratification or through the PD? As we know, the PD has the force of statute and thus is like an enactment of a statute by Congress. So that's the question, Attorney Quintin.
Yes, I thank you. I think it was domesticated through the presidential decree number 207. This, of course, has the force and effect of a statute, no? And this power was exercised by President Marcos pursuant to Proclamation number 1081. So yes, it was domesticated through the presidential decree number 207, and the International Convention has attained the status of a statute.
Okay, thank you. And this next question is for Attorney Aguilar, for Nico. So Nico, you referred in your slide. Can we show the slide, please? Yeah. Okay, so in your slide, you referred to RA 9851, which reproduced the rules of the Geneva Conventions. And so these Geneva Convention rules, they are now part of Philippine statutory law. Do we need to invoke the domesticated customary law to obtain the relief that we seek? Can't we just use RA 9851?
Okay. In this particular case, as I have mentioned, the gap by which this domesticated rule of international law is trying to resolve by way of a reasonable inference from that rule, vis-a-vis the relief that I wanted to get is that the gap is the RA 9851 and even the Geneva Conventions do not expressly mention this kind of situation, the red tagging situation. It only RA 9851 only talks about the kinds of attacks that we normally understand, like attacks, meaning you bomb civilians, you launch tactical offensives, but it did not recognize red tagging which may also be considered as an attack, or which may also be considered as as a military offensive. And I think that that particular kind of attack or red tagging as a phenomenon is a direct violation of the customary rule that I am invoking, which is the principle of distinction between civilians and military objectives. And I think that that kind of principle is not also expressly reflected under RA 9851, and hence it calls for the need to apply the domesticated rule of international law on the principle of distinction in order to obtain the relief that I am seeking through this domesticated rule.
Thank you, Attorney Aguilar. Question for our next presenter, Attorney Avila. Attorney, the slide, please. Next slide. Okay. So for Anton, can you please clarify the effect of the domesticated international rule? Does the rule fill a gap in Philippine law, or does it result in a reinterpretation of the constitutional exclusionary rule?
Okay, thank you, Professor. So I'm arguing that it is not in conflict with the current jurisprudence regarding the doctrine of the fruit of the poisonous tree. The Bill of Rights, as currently held in doctrines, would still still only be invoked against state agents, but to exclude evidence in violation of privacy rights, the ICCPR can be used as legal basis for such an exclusion. So it's not in conflict. I argue that it's not in conflict with the current constitutional doctrine, but it's an added legal basis for exclusion of evidence, and you could think of it as something that fills a gap in the evidentiary rules.
Thank you, Attorney Avila. I'll now invite the next three presenters. So for the first one, we have Attorney Gary Villarreal. He'll present online.
I'm Attorney Edgardo Villarreal II. And my topic is all about the different pay rates for regular holiday and special day or special holiday as we know it. Pursuant to the constitutional supremacy, when the terms of the statute are not exactly the same as that of the treaty, the one which is more consistent with the Constitution shall prevail. And for such reason, the provision of the International Covenant on Economic, Social, and Cultural Rights may be relied on to underscore, clarify, or reinforce the mandate of the 1987 Constitution towards full protection to labor. Incidentally, the Philippines is a signatory to the Covenant, the ICCR, since December 19, 1966, and is one of the 184 member states of the United Nations that has ratified the same on June 7, 1974. While it is uncertain whether Senate's concurrence was previously obtained, the fact that the Supreme Court has cited the same in some of its decisions is a clear manifestation of the country's recognition and commitment to be bound by it. Both the Labor Code as amended and as well as the International Covenant on Economic, Social, and Cultural Rights guarantee the right of employees to a holiday pay. For instance, Article 7 of ISSCR provides that the worker is entitled to a remuneration during public holidays. And this is without any distinction of any kind. On the other hand, under our labor code, it differentiates regular holidays from special days in terms of payment of wages. We all know that in the former, an employee is not paid if he is not working during in regular holiday, the employee is paid even if he is not working. But with regard to special days, the employee is not paid at all, unless he works on such day, in which case he is paid an additional premium of 30%. But then the constitutional mandate is clear. The state affords full protection to labor. And now that the Christmas season is around the corner, for a minimum wage like an ordinary worker, it means looking for an extra budget to spend for the season. And with the rising cost of goods nowadays, coupled by the fact that in at least 3 occasions for December, an ordinary worker would not earn his salary during special days, namely December 8, December 24, and December 31. Definitely, it will be a much of a headache for an ordinary worker. And for them, or for us, we are wondering why there is a distinction in the pay rate between regular holiday and special day, despite the fact that they are both considered public holidays. If the intent of the law is to give remuneration during a regular holiday for the purpose of preventing a diminution in the income of employees, there is no reasonable distinction between regular holiday and special day. That regular employee, that ordinary employee, may consider filing a petition for certiorari questioning the constitutionality of Article 94 and 93, providing for a distinction between regular holiday and special day in terms of payment of employees. And that is, I think, consistent with the power of the Constitution to interpret the laws and, that is consistent with the power of the court to interpret the laws and the Constitution. Because courts will not follow the letter of the statute, when to do so would depart from the true intent of the legislature and would otherwise yield to conclusions inconsistent with the general purpose of the act. Laws have ends to achieve, and statute should be so construed so as not to defeat, but to carry out such ends and purpose. That kind of judicial interpretation is not novel in this jurisdiction. It has been done in the past, wherein the Supreme Court would make a different interpretation despite the clear letter or the plain words used in the statute. It has been done in the past in the case of Mercado versus Manzano, wherein the Supreme Court held that the true meaning of dual citizenship, as stated in Section 40 of the Local Government Code, is actually dual allegiance. Likewise, in Philippine Guardians Brotherhood Incorporated versus COMELEC, in view of its ruling in the case of Minero versus COMELEC, the provision under the Party List System Act, specifically Section 6, Paragraph 8 thereof, which provides that one of the disqualification or cancellation of registration or grants for the cancellation of registration as provided in the law, that failure to obtain at least 2% in the votes cast under the party list system should now be redefined and should now be read as failure to qualify a seat in the party list election in the 2 preceding elections. Thank you.
Thank you, Attorney Villarreal. Next, I'll call on Attorney Marian Betug.
So good morning, everyone. My name is Marian Betug. I am a lecturer at the UP College of Law, Diliman campus. So my submission is that stealthing should be considered rape under the revised penal code or the RPC. Stealthing is defined as the non-consensual act of removing a condom during sexual activity without the awareness or consent of the other person involved. So under Philippine law, there is no statute expressly criminalizing stealthing. There is also no Supreme Court decision recognizing it as a crime. The relief sought here is thus the authorization of a court to consider stealthing a form of rape under Article 266 of the RPC by applying Article 3 of the Convention on the Elimination of All Forms of Discrimination Against Women, or the CEDAW. So Article 266A of the RPC states that one method by which rape is committed is having carnal knowledge of another person by means of fraudulent machination. So the key phrase here is fraudulent machination. Meanwhile, in Article 3 of the CEDAW, it states in part that states parties shall take all appropriate measures to ensure the full development and advancement of women for the purpose of guaranteeing them the exercise and enjoyment of human rights and fundamental freedoms on a basis of equality with men. So the crucial aspect of this obligation is the guarantee of fundamental freedoms that women should enjoy equally to men. So the CEDAW is an international agreement signed by the Philippines on July 15, 1980 and ratified on July 19, 1981. It entered into force generally for the states parties on September 3, 1981. Its optional protocol was also signed by the Philippines on March 21, 2000, ratified on June 23, 2000, and concurred in by the Senate on October 6, 2003. It entered into force for the Philippines on February 12, 2004. It is thus binding on the Philippines and has been domesticated by transformation. As there is no existing statute or decision regarding stealthing, there is no conflict with Philippine law. And so I argue that stealthing evidently impinges on the fundamental freedoms that should be enjoyed by women pursuant to the CEDAW. It violates their inherent dignity as individuals who are accorded human rights equal to men. The basis of sexual relations between parties of equal standing should be consent, and this includes the use of contraceptive methods. The non-consensual removal of a condom during sexual intercourse violates this consent. In the context of heterosexual intercourse, stealthing is an act of control by men and a reflection of the unequal power dynamics between men and women, as only men would be able to commit this deceit. Stealthing should be considered fraudulent machination because one of the parties induces the other to engage in sexual intercourse on a false premise that they would be protected by a condom. So as we know, the use of a condom prevents sexually transmitted infections and unwanted pregnancies. It is highly likely that the other party would not have consented to sexual intercourse without contraception. The removal of a condom without the other party's knowledge or consent thus changes the conditions that they agreed to and violates the other's consent. Women, who should, as human beings, be guaranteed the fundamental freedoms equal to men, should have the liberty to decide the circumstances under which they agree to sex. I note that this present analysis is limited only to the context of heterosexual intercourse. However, it does not preclude its application to persons of diverse sexual orientations, gender identities or expressions, or sex characteristics, or so GSC, by extension of this analysis or on the basis of other international agreements, given the fundamental human rights equally accorded to these individuals. So women, no matter their SOGSC or those of their partners, are entitled to the same protections after all. So in conclusion, the right to bodily autonomy, the right to make informed reproductive choices, and the elimination of gender-based violence are foundational to the CEDAW. Thus, pursuant to Article 3, stealthing should be viewed as fraudulent machination under Article 266 of the RPC. Thank you for your time and attention.
Thank you, Marian. Next, I'll invite Attorney Carl Mondihar.
So, good morning, everyone. I am Carl Vincent Mondehar. So, my topic for today would be women subjected to honor-based killing. So, honor-based violence, if, as we all know, is defined as an offense committed against women, which has or may have been committed to protect the honor of the family and or the community. So with this culture of violence, in some jurisdiction, laws have been placed to defend, or rather laws have been placed in defense of husbands and the family members from criminal liability for those who commit violence towards the female members of their society if these women's sexual behaviors defy the cultural or social norms, besmirching the patriarchal concept of honor or reputation. So in the Philippines, we have this similar law, and we are all aware of Article 247, inflicting of injuries or death due to exceptional circumstances. So we will focus on paragraph 3 of Article 247 of the Revised Penal Code, which states that the rules shall be applicable under the same circumstances to the parents with respect to their daughters under 18 years of age and their seducer while the daughter is living with her parents. So the main focus here in this paragraph is the word daughters. And it's clear now that if the same happens to the son, there is no justified, or rather the infliction of death or physical injury is not justified. So as compared to the usual penalties that we have for killing someone or inflicting injuries, the penalty now here for Article 247 is destierro or banishment. And if we, based on what we learned, destierro is rather for the protection of the convict, because we try to prevent the scenario wherein the family of the killed person retaliates against the convict. So now we have this international instrument called ASEAN, which we have signed and ratified on 1981, and on 1981, considering that this is before the 1987 Constitution, by virtue of the powers of the Prime Minister to enter into international agreements based on its best interest. So even though we have ratified this, or rather the Senate has concurred this later on in the year 2000, this CEDAW is binding on the, or rather as an international agreement and via transformation. So now the CEDAW here, Article 2, the states parties condemn discrimination against women, and to this end undertake to take all appropriate measures, including legislation, to modify or abolish existing laws, regulations, customs, and practices which constitute discrimination against women. So now, the relief I'm trying to seek is to declare Article 3, or rather Paragraph 3 of Article 247, which applies the defense and the penalty of merely destierro against minor children. But now we have to ask the question as to why are we trying to render a domestic law unconstitutional using international law, because we know for a fact, and based on the lectures by Professor Raj, we cannot do that. So now what I'm trying to do is I will give flesh and bone to the Equal Protection Clause and render Paragraph 3 as unconstitutional, because the Equal Protection Clause, diba, we render any legislation as unconstitutional if it is discriminatory. So clearly, Paragraph 3 is gender-based discrimination, since it makes the killing of a daughter justifiable, but the killing of a son is not justified. That is why giving flesh and bone to to the Equal Protection Clause of the 1987 Constitution, and using this Equal Protection Clause as the basis for rendering paragraph 3 of Article 247 as unconstitutional. The relief sought now, which equalizes men and women, is achieved. So thank you and good morning.
Thank you, Attorney Carl. We'll ask the presenters a few questions, no? For Attorney Villarreal. Wait. Okay, for Attorney Villarreal, are you there? Okay, great. So, Attorney Villarreal, can we flash the slide, please? So you invoke the International Covenant on Economic, Social, and Cultural Rights, where a worker is entitled to remuneration during public holiday without distinction of any kind. Also, you referred to the constitutional the constitutional policy of full protection to labor, whether domestic or overseas. Do we really need to use the international rule to obtain the relief that we seek? Can't we just use this constitutional policy of full protection to labor?
I think, sir, I respectfully submit that there is a need to invoke the provision of ICSCR in order to clarify, reinforce, or underscore the constitutional protection on full protection to labor in view of the clear mandate under the labor code, clear provision under the labor code, providing for the distinction between a regular holiday and a special day. As compared to the provision of the ICSCR that a worker is entitled to a remuneration during public holidays without any distinction at all. So in order to achieve or to construe that full protection to labor, I think ICSCR may be relied on.
Thank you, Attorney Villarreal. The next question is for Attorney Betug. Can we flash the slide? So, Attorney Betug, in your presentation, I think you referred to the effect of the domesticated international rule on the Philippine statute, RPC, Article 266A. And if I understand correctly, the effect is that the CEDAW provision will result in a reinterpretation of the revised penal code such that stealthing will now be considered a form of rape. So CEDAW, which is on the same level as a statute, may result in that kind of interpretation or reinterpretation of RPC. However, I'm also aware of a principle in criminal law, and I think this may be based on the constitutional rights of an accused, that the revised penal code or penal provisions should be interpreted in favor of the accused. So how do we balance those two?
Okay, thank you, sir. I'll answer that question on two levels. So firstly, I think that it's not necessarily a reinterpretation of Article 266 of the RPC because there is no provision explicitly dealing with stealthing. So rather, I argue that it's a new interpretation of the provision because it gives the courts the authority to declare stealthing as a form of fraudulent machination. But on the second level, I understand that there is a criminal law principle that statutes should be interpreted in favor of the accused. However, this doesn't mean that, for example, when we determine whether or not certain acts fall within the definition of certain crimes, it doesn't mean that we always assume in favor of the accused that particular modes cannot be interpreted or rather that they cannot be applied to particular actions. Rather, we check whether or not this particular set of actions is something that falls within the definition provided by the statute. And so here, because fraudulent machination is broad enough to encompass the act of stealthing, I think that it does not necessarily go against that principle. And moreover, I think there's also an equally relevant constitutional principle that women should be guaranteed equality with men, and therefore considering that this is an act that displays an unequal power dynamic between men and women, that should be equally considered by a court whenever the issue of stealthing is brought up in a criminal case before it. Thank you.
So thank you, Marianne. Question for Carl. Can you flash your slide? Okay. So you pointed to RPC, Article 247, Paragraph 3, and also to CEDAW. Do we need to use this CEDAW provision to obtain the relief that you seek? Because I understand that CEDAW is only on the same level as statute, and you're using CEDAW to give flesh, as you said, to the constitutional provision on equality of sexes. Now, there is a statute existing in the Philippines. Can't we use that statute to give flesh to the constitutional provision on equality of the sexes? And this statute is the Magna Carta of Women, so that we don't have to use the rule of international law.
Thank you, Professor. So as to I'll answer the second question first. So yes, we have the Magna Carta for women, but this Magna Carta for women does not expressly repeal, or rather does not expressly repeal paragraph 3 of Article 247, and on its own, the Magna Carta for women cannot operate and cannot be used as basis to invalidate paragraph 3. So now we are using, or rather we are calling on to the Equal Protection Clause of the 1987 Constitution to render this paragraph 3 unconstitutional, because we need to adhere to our international obligations under the CEDAW, which is to give equal protection and appropriate measures to abolish existing laws, regulations, and customs. So now, if we apply Equal Protection Clause and use the express obligation under the CEDAW to modify or abolish existing laws, then we can have a clear avenue or vehicle to achieve our relief being sought, which is the equal treatment between women and men, Professor.
Thank you very much, Carl. I'll now invite the last three presenters among the LEAF Fellows. So first would be Dean Rodel Taton.
Hey guys, good morning. To my Twitter mutuals who are here, good morning. My topic is online sexual exploitation through Twitter using hashtag baguettes. So this is actually looking at the Budapest Convention on Cybercrime as basis for DOJ to prosecute Twitter's hashtag baguettes as online sexual exploitation offense for children in the Philippines. And we know that during the pandemic, online sexual exploitation offenses, particularly for children, became prevalent online, and we see it, yet it continues to sprawl in social media like Twitter. Patrons are just there 24/7, and we call it hashtag baguettes. And such acts would refer to a wide array of acts of abuse or exploitation committed online and using computer systems. If this specific platform can offer and engage children to exploitation, it is imperative to implement the provisions of the Budapest Convention on Cybercrime, to which the Philippines acceded to in 2018. Thus, the Budapest Convention on Cybercrime actually was entered into force in 2004. It was originally a Council of Europe's convention where the Philippines is an observer in 2001, and in the Philippines acceded to it and signed and ratified in 2018. So here, while Well, the Supreme Court admitted as electronic evidence photos in Messenger application of Facebook. There are no cases yet that are directly being filed in relation to Twitter violations. I know this is controversial, but we know also that the online sexual exploitation for children, is a collective term for various offenses, and it is not specifically defined as a crime under a particular law in the Philippines. Although we have, in addition to the revised penal code, there are 4 related laws here. We have RA 9775, the Anti-Child Pornography Act of 2009, RA 9208, Anti-Trafficking in Persons. We have the Cybercrime Prevention Act of 2012, and of course, RA 7610. But again, it is clear here that the legal framework on online exploitation of children should be looked into if there is a need to define or redefine or bridge the gaps between these laws. And that is through the Budapest Convention, which would make the Philippines that should make the Philippines and the Department of Justice to prosecute and implement measures, especially for the investigation of criminal offenses in relation to this exploitation online. So if you look at Article 9 of the Budapest Convention, it empowers the states here, like the Philippines, to implement measures that should protect the children. And we know that this treaty has been domesticated in the Philippines, and we have laws, but there is a need to bridge the gap in these existing provisions. And I think with the current events in social media or in Twitter and existing in different platforms, especially in the hashtag baguettes, it must empower the DOJ to prosecute such online exploitation, particularly of children. Thank you.
Thank you, Dean Taton. Next, I'll invite Attorney Jox Dilag for his presentation.
Hi, good morning, everyone. I'm Jox Dilag, one of the LEAP Fellows and a faculty of the UP College of Law. And I am proposing an application of international law in this very interesting field of law, taxation, particularly as regards this recurring tax problem pertaining to the taxpayer's right to an effective remedy for deficiency tax assessments. So as you may know, one of the functions of the Bureau of Internal Revenue, or the BIR, is to conduct an audit of taxpayers' books of accounts to verify whether there are any unpaid taxes. After due process, the BIR comes up with what we call a deficiency tax assessment that lists down the types of taxes and the unpaid amount. Ideally, a taxpayer will be amenable to the payment of deficiencies for as long as they are consistent with the records of the taxpayer. Unfortunately, that is not usually the case, as the audit process would sometimes disallow certain items of expenses or categorize irreconcilable differences as undeclared revenues, eventually increasing the amount of taxes still due to the government. In case of disagreements, the matter can only be elevated to the Court of Tax Appeals, or the CTA, that will serve as the adjudicator. Unfortunately, there has been several violations of the taxpayer's right to due process during the audit process that resulted in bloated deficiency taxes or tax assessments that are enough to bankrupt companies. So for a moment, imagine you are a very small firm, probably a travel agency, that only earns 1 million in net profits every year. And then suddenly, the BIR audits you and assesses you for deficiency income tax and VAT amounting to 300 million pesos because you apparently did not report as income the airfare prices that you receive but never was part of your gross income because it will be paid to the airline provider, right? The BIR, not listening to you, has issued its final decision, and your only recourse is to go to the CTA and pay around 3 million pesos in filing fees. Now, Does it make sense to just settle with the BIR at an amount lower than 3 million and give up on your rights? I don't think so, and so does customary international law. What I propose as a solution is to authorize the taxpayer to pay minimal filing fees if it is alleging grounds on gross violations of due process, to cancel assessments, and to charge the remaining to the erring party. The problem exists because the CTA requires approximately 1% of the assessment as filing fees before it can assume jurisdiction. So if the taxpayer has no funds to fund this, it is left with no choice but to either allow the assessment to be final and executory, or to find a way to have the matter settled amicably, with the taxpayer on the losing end either way. How is this setup compliant with our international obligations to an effective remedy? Article 8 of the Universal Declaration of Human Rights, or the UDHR, provides that everyone has the right to an effective remedy by competent national tribunals for violating the fundamental rights granted him by the Constitution or by law. Given that the UDHR is not a settled binding source of international law, it is, however, an embodiment of customary international law that respects the right of everyone to an effective remedy. The right has been repeated in several other international instruments that obligate state parties to ensure effective remedies, even if the violation was committed by a person in an official capacity, and for such right to be determined by competent authorities. Without a doubt, our country has acknowledged the right of to an effective remedy as a customary international law by our very own Supreme Court, where Justice Kagiwa, in his dissenting opinion, cautioned us to avoid confusing the right from the mechanisms that enforce it. Given that procedural rules must always give to substantive rights, or give way to substantive rights, there is basis for an aggrieved taxpayer to implore the aid of the judiciary, specifically the Court of Tax Appeals, to allow some form of opportunity to present its case without indirectly being gatekept by the BIR through baseless and inflated assessments. Now, what is an effective remedy, you may ask? According to esteemed writers in the legal profession, it may involve a relief that restores the claimant to the same position occupied prior to the commission of the wrong. If not possible, then compensation is the next best thing, which is usually the case. Translated domestically, that could mean refund of already paid filing fees in the form of tax credits that would dramatically discourage the BIR from committing the same mistakes again in fear of losing tax revenues, or simply by allowing an appeal on minimal filing fees and the remainder being charged against the erring party post-adjudication. Thank you very much for listening.
Thank you, Attorney Jocks. And the last but not the least among the LEAP Fellows, Judge Kimbo.
Professor Palacios, ladies and gentlemen, good morning. Is quasi-delic under Article 2176 of the Civil Code the only source of civil liability in connection with an oil pollution damage in Philippine waters? The answer is in the negative. Under Article 2176 of the Civil Code, whoever by action or omission causes damage to another, there being fault or injury or negligence, shall be held liable for the damage. So based on this provision in the Civil Code, the commission of a grossly negligent act serves as a basis for a court of competent jurisdiction to award civil liability in favor of an aggrieved party. However, under the 1992 Civil Liability Convention, to which the Philippines acceded sometime in 1997, the basis for an award of civil liability which a court may use in connection with an oil pollution damage is the mere existence of an oil pollution damage in Philippine waters. In other words, it uses the strict liability tests so that the court can award civil liability in favor of an aggrieved party. Now, this is different because the court, in order to award civil damages in favor of an aggrieved party through an ordinary civil action or a suit for damages, is not the commission of a grossly negligent act. However, the court can do the same by simply looking at the evidence adduced by the aggrieved party if there is such an oil pollution damage that occurred within Philippine territory. So, this representation humbly submits that the recovery of civil liability based on the 1992 Civil Liability Convention is easier when compared to the recovery of civil liability based on quasi-delict. However, my opinion is this international convention does not collide with Article 2176 of the Civil Code. Neither does it impliedly repeal Article 2176 of the Civil Code because in this jurisdiction, implied repeal is disfavored or frowned upon. My submission is it simply gives or provides an alternative source of liability which a court of competent jurisdiction can use as basis so that an aggrieved party can claim damage arising from an oil pollution damage. Thank you and good morning.
Thank you, Judge Kimboy. We have a few questions for Dean Rodel Taton. So the question is, so we have the mic there. So can you show the slide? Yes, okay. Do we need the rule of international law to compel DOJ to prosecute online sexual exploitation? Can't we just use the Cybercrime Prevention Act or the Child Pornography Act, which imposes on DOJ the duty to prosecute these crimes?
Thank you. We have to understand that the online sexual exploitation offenses are not well defined in the 4 specific laws that I have mentioned today. And all these laws, if ever, can make a Twitter handle owner not liable for offenses under #baguettes, because we know that this is a business for some of these people, and this is not only an individual for some, but also a company for exploitation of children. And I think that this rule on international law can bridge the gaps between the existing laws. And I think this will actually cement the prohibition and the authorization for the DOJ to prosecute offenders for this online sexual exploitation, because we really need to, the law enforcement for the criminal justice system is really something that we need to strengthen. Thank you.
Thank you, Dean Rodel. For Attorney Jocks. Okay, so can you please clarify the effect of the customary law on the CTA rules? Is there a conflict or is there a gap?
So there is a seeming gap in the application of the right, because the right to an effective remedy makes sure that you are able to use the facilities available for you to appeal your case, right? And it's not an effective remedy if the thing that prevents you from actually exercising your right is filing fees, which is a procedural rule, right? So since procedural rules must always give way to substantive rights, which is the right to an effective remedy, then it fills the gap on how can those that might not even have the funds to pay such large filing fees be able to still tap the jurisdiction of the Court of Tax Appeals to settle the issue on their plea for cancellation of these assessments.
Thank you, Attorney Jocks. And for Judge Kimboy, Judge explained the effect, right? You explained the effect of the international agreement rule, which imposes strict liability on the ship owner on existing Philippine legal rules set out in Article 2176. And you did say there's no conflict, right? So if there's no conflict, can you say that there's a gap being filled by the international agreement rule, or it will result in a reinterpretation of grounds for liability for certain acts? I don't know. What's the effect?
I think, Professor, it provides another legal avenue for an aggrieved party to recover damages. Because under the Civil Code, the basis for an award of civil liability is the grossly negligent act. But in the case of this international convention, once the aggrieved party establishes the existence of an oil pollution damage, the existence of a grossly negligent act becomes immaterial or irrelevant. So somehow it fills a gap, Professor, because it enables the aggrieved party to recover damages based on the mere existence of this oil pollution damage without being burdened by the duty to adduce evidence in order to show that there was a grossly negligent act.
Thank you very much, Judge. I'd like to invite everyone to again give a big round of applause to our LEAP Fellows. So the ones who presented today will be attending the graduation activity this afternoon, right, in UP Diliman. So those present, may I invite you to please stand and come forward. And then maybe Ken, is Ken here? We'll ask Ken to take a photo. Yan. Sige, please come in front. So Attorney Quintin from Baguio, Attorney Nico Aguilar, also from Baguio, Attorney Anton Avila, also from Baguio, tama ba? Baguio also, talagang well represented, ha? So yung ating first three presenters were all from Baguio. Attorney Villarreal, I don't know where Attorney Villarreal is from. Attorney Betug from Manila, Attorney Mondihar from Iloilo, Dean Taton from Metro Manila, at also from Iloilo, Attorney Dilag, Metro Manila? Okay. And Judge Kimbo from Bataan. Okay, let's give them a big round of applause. Congratulations to our LEAP Fellows. So they will have their graduation this afternoon. Okay? We're hoping that they can... Ay, sige. So hopefully, if they allow, we can have a symposium with their students next sem. So one possibility is, if they're willing, we can invite their students to join us in our symposium next sem, or we can do a symposium in their area, and then we can do a mega symposium, best of the best, right? Oh, so that one we can do. Okay? So thank you very much to our LEAP Fellows. Please feel free to stay. We'll now move to two LL.M students. LL.M students are supposed to present tomorrow. However, these two are not available tomorrow, so they will be presenting this morning. And there are two of them, Attorney Noriz Castillo. Tama, is she there? Attorney Noriz is there?
Yes, Prof.
Okay, great. Attorney Noriz Castillo of the Philippine Space Agency. Is that right? Tama
Yes.
ba? Ayun. Okay, and Attorney Allen Joel Pita, a private practitioner from Cebu. Okay? So let's listen to Attorney Noriz first and then to Attorney Pita afterwards.
Good morning, everyone. This case study is about Mr. Juan de la Cruz, a Filipino businessman who wants to operate a ride-sharing business in the Philippines. For his fleet, he acquired vehicles that were manufactured in Malaysia, and each vehicle had a roadworthiness certificate issued by the Transport Ministry of Malaysia. He applied with our Land Transportation Office to register the vehicles. He was told, however, that he needed to secure a motor vehicle inspection certificate from the accredited entities of the LTO in the Philippines for each of the vehicles. Mr. De La Cruz presented the certificate issued by the Transport Ministry of Malaysia and requested that these be accepted as equivalent to the required motor vehicle inspection certificate being required by LTO. The problem is that the LTO does not recognize the roadworthiness certificate issued by a non-Philippine ASEAN state as equivalent to the motor vehicle inspection certificate requirement for motor vehicle registration. The applicable domestic rule being followed by LTO is its LTO-issued checklist of requirements for motor vehicle registration as published in its website. These are copy of appropriate insurance certificate of cover or the third-party liability. Number 2, which is the relevant to our case study, is duly accomplished original motor vehicle inspection report or the MVIR. And last is the original copy of certificate of emission compliance. On the other hand, the relevant international law is the agreement on the recognition of commercial vehicle inspection for goods, vehicles, and public service vehicles issued by ASEAN member countries. Article 1 of this agreement states that the contracting parties agree to recognize the valid commercial vehicle inspection certificate with respect to goods, vehicle, and public service vehicle issued by the designated authorities of the contracting party. And Article 2, by virtue of the recognition of the certificate, any commercial vehicle intended to be brought into and used in the territory of any of the contracting party may not be required to undergo any roadworthiness inspection in the host contracting party. Applying the 7-step process in determining the status and effect of this ASEAN law in our domestic Philippine law, we find that the source of this rule is an ASEAN treaty signed in Singapore on September 10, 1998. It is binding on the Philippines, having been ratified by the President of the Philippines on September 29, 1999, and it entered into force on November 27, 2006. Hence, it has been domesticated through the process of transformation, in addition to the incorporation clause in our 1987 Constitution. There is no indication that this treaty that was ratified by President was concurred by the Senate. Thus, in the hierarchy of rules, this agreement is equivalent to an executive agreement. The effect of the provisions of this domesticated treaty in the Philippines is that it is now in conflict with the LTO-issued rule requiring motor vehicle registration certificate before a motor vehicle is allowed to be registered. The relief being sought is to authorize LTO to approve the registration of a motor vehicle on the basis of a roadworthiness certificate issued by a non-Philippine ASEAN state, in this case by Malaysia, by the Transport Ministry of Malaysia. But under the LTO issued rule, there is no provision that recognizes roadworthiness certificate issued by a non-Philippine ASEAN state. Hence, there is a conflict. To resolve the conflict, we compare the standing of the ASEAN Treaty with our domestic rule. The ASEAN Treaty on the recognition of commercial vehicles inspection is in the nature of an executive agreement, as discussed earlier. In contrast, the LTO issued rule requiring a motor vehicle inspection report is in the nature of a mere rule or guideline, which is inferior to an executive agreement that was ratified by the President of the Philippines. Applying the principle of lex superior derogat lex inferiori, therefore, the ASEAN Treaty as a superior law trumps the LTO-issued guideline. Hence, on the basis of the ASEAN Treaty, LTO is authorized to register the vehicles of Mr. Juan de la Cruz in recognition of the roadworthiness certificates issued by the Transport Ministry of Malaysia. Thank you for listening.
Okay, thank you, Attorney Castillo. We'll next invite Attorney Pita.
The Philippine The Philippine legal problem for my case study is that insolvent non-Philippine ASEAN cooperatives cannot avail of voluntary financial rehabilitation. Under RA 10142, or the Financial Rehabilitation and Insolvency Act, or the FRIA, insolvent debtors who can avail of financial rehabilitation are only of 4 types, namely, first, a sole proprietorship duly registered with the DTI. Second, a partnership duly registered with the SEC. Third, a corporation duly organized and existing under Philippine laws. And fourth, an individual debtor. A cooperative does not fall among the mentioned 4 types of debtors. Under Philippine law, while a cooperative has a juridical personality after it is duly formed and organized under the Philippine Cooperative Code, it is not legally a corporation, much less a partnership, sole proprietorship, or individual. There are no other Philippine rules from domestic sources which authorizes a cooperative to avail of voluntary financial rehabilitation. In this regard, considering that financial rehabilitation is not an available remedy, cooperatives will then be constrained to proceed to liquidation in case they become insolvent, thus depriving them of the opportunity to revive their business. Based on my personal real-life experience, this Philippine legal problem is more real than merely academic. I had an actual experience of filing before the RTC a petition for voluntary financial rehabilitation of an insolvent cooperative, but the RTC dismissed the petition on the ground that a cooperative is not among the debtors who can avail of voluntary financial rehabilitation under Philippine law. If Philippine cooperatives cannot clearly avail of financial rehabilitation, then the same is certainly true to non-Philippine ASEAN cooperatives. The relief sought for my case study is to authorize non-Philippine ASEAN cooperatives to avail of voluntary financial rehabilitation proceedings. The ASEAN law solution that can be used to obtain this relief is the ASEAN Comprehensive Investment Agreement, or ASEAN, particularly Article 11, Paragraph 2 thereof. By applying the 7-step process, this ASEAN legal rule can serve as basis to grant this unique form of legal relief. The ASEAN is a binding rule in the Philippines, being in the nature of an executive agreement which was signed by the Philippine representative on February 26, 2009, and ratified by the President on August 6, 2009. In this regard, the ASEAN has been domesticated in the Philippines in the same level of an executive regulation. Thus, the ASEAN can be used for reinterpretation of Philippine rules, particularly Section 4, Paragraph K of the FRIA on the definition of debtor, considering that there is no conflict between these two laws. Section 4, Paragraph K of the FRIA should then be read in conjunction with Article 11, Paragraph 2 of the ASEAN, which requires each member states to take such measures to ensure the full protection and security of the covered investments. Under the ASEAN, cooperatives are certainly considered as covered investments. In this regard, the Philippines has a binding obligation to give full protection and security to non-Philippine ASEAN cooperatives, which should necessarily include the right to avail of voluntary financial rehabilitation. Thus, by applying the well-accepted rule of statutory construction that to the extent possible, laws should be harmonized and not read as creating a conflict, Article 11, Paragraph 2 of the ASEAN can serve as legal basis for reinterpretation of Section 4, Paragraph K of the FRIA, particularly on the definition of debtors, to authorize non-Philippine ASEAN cooperatives to avail of voluntary financial rehabilitation proceedings. Thank you.
Thank you very much, Attorney Pita. We have some questions for Attorney Castillo. Noriz? Okay, so for Noriz, can we flash her slide? Okay. We have a few questions. Can you please clarify how the ASEAN rule was domesticated. So as you mentioned, it's an international agreement. How was it domesticated? By transformation or incorporation? And second, do we need the ASEAN rule to obtain the relief that we seek? Can't we just use existing Philippine rules like those in the Ease of Doing Business Act, formerly the Anti-Red Tape Act?
Yes, Prof. Thank you for the question. The ASEAN rule was domesticated when it was ratified by the President of the Philippines on September 29, 1999, and then it took into effect, entered into force on November 27, 2006, hence domestication via transformation. And can we use other government laws to obtain the relief that is being sought? I believe specifically the Ease of Doing Business Act. A reading of the Ease of Doing Business Act will show that it deals with procedures, simplifying requirements and procedures. There is no direct provision regarding applying ASEAN treaties or other treaties to procedures. Hence, it is my submission that proposition that the LTO will need to cite this ASEAN treaty in order to have basis to simplify its rule that to recognize this non-Philippine ASEAN state issued motor vehicle certificate, inspection certificate.
Okay, thank you very much, Noriz. For Alan, the question for Alan is, I think Alan said that under the AKIA, the ASEAN Comprehensive Investment Agreement, an ASEAN investor will be given certain rights. Okay? The investment of the ASEAN investor will be protected under Article 11(2)(b), right? So if the ASEAN cooperative investor will be able to file a voluntary rehabilitation proceeding, would the ASEAN cooperative then be enjoying a right not enjoyed by a Philippine cooperative? So the foreigner will have more rights than a Filipino.
Thank you, Professor, for the question. I believe if the Philippines will authorize non-Philippine ASEAN cooperatives to avail of voluntary financial rehabilitation, then I think it would necessarily follow that Philippine cooperatives organized here in the Philippines would also be entitled to that voluntary financial rehabilitation proceedings. Because in order to obtain this legal relief, there has to be a reinterpretation of the domestic law, which is the Section 4, Paragraph K of the FRIA, the Financial Rehabilitation and Insolvency Act. So if the FRIA will have to be reinterpreted so as to include cooperatives in the definition of debtor who can avail of voluntary financial rehabilitation, then I believe it would necessarily follow that Philippine cooperatives organized and registered in the Philippines would also have to be entitled with this privilege to avail of voluntary financial rehabilitation.
Alan, ayo-ayo sa Cebu. Okay, sige. So we had those two LLM students presenting ahead of their classmates because they're not available to present tomorrow. So after the LEAP Fellows, we're really supposed to have our J.D. students doing their presentations. Okay, so now we can do that. I think the J.D. students are raring to give their presentations. They've prepared long and hard for this. I hope not too many sleepless nights. Okay. Usually for each session of the symposium, we usually invite the class BDEL to kick off the presentations, right? So for this JD section, we're going to invite the BDEL for section G of the UP Diliman section, and we'll invite Antoy Rodriguez to begin her presentation and also introduce the next one. No? We'll take a break at after the fifth presenter so I can ask a few questions. Okay.
Okay, so good morning, everyone. My name is Maria Antoinette Rodriguez, and on behalf of Class 3G and the JD students, I would first like to thank our professor, Sir Raj, for his guidance in helping us create our presentations and appreciate the role that public international law plays in our legal system. We hope that with our presentations, we may share the knowledge that we've obtained throughout the course of this semester. So without further ado, I will be starting the case presentations of the JD students. My topic is the Convention on the Elimination of All Forms of Discrimination Against Women, or the CEDAW, as basis to authorize a mother to impugn the legitimacy of her child. The problem I want to address is the fact that in the Philippines, only the father and in some cases his heirs may impugn the legitimacy of a person. For instance, a man and a woman got married. A few months into the marriage, the husband became abusive, so the wife left. A few years later, while the spouses were estranged and during the subsistence of their marriage, the wife met and fell in love with another man, and they had a child that they decided to name Junior. And they were living a happy and peaceful life. When the husband found out, he wanted to be spiteful and publicly claimed the child as his own, using the presumption in the law in his favor. He, however, had no intention of actually supporting Junior. Because of the undue stress that the husband's bothersome behavior was causing them, the mother wanted to impugn the legitimacy of Junior by filing an action to impugn legitimacy to finally cut ties with the abusive father. This is regardless of the risks that it may entail to her reputation or the possible charges against her. However, under the status quo, she is not allowed to do so. Article 167 of the Family Code states that the child shall be considered legitimate, although the mother may have declared against its legitimacy or may have been sentenced as an adulteress. Furthermore, other provisions in the Family Code relating to impugning legitimacy, such as the prescriptive periods for filing the action to impugn, talk only about the father or his heirs. Nevertheless, there is no actual express prohibition in the law against a mother impugning the legitimacy of a child. It is the Supreme Court, in several cases, which ruled that only the father, and in exceptional cases his heirs, may impugn the legitimacy of a child because he is the one directly confronted with the scandal and ridicule which the infidelity of his wife produces, and he should decide whether to conceal that infidelity or expose it in view of the moral and economic interest involved. To remedy this problem, the CEDAW may be used as a basis to authorize the mother to impugn the legitimacy of her child by an action to impugn legitimacy. The specific provision in the CEDAW is Article 16(1)(d), which states that states parties shall take all appropriate measures to eliminate discrimination against women in all matters relating to marriage and family relations, and in particular, shall ensure, on a basis of equality of men and women, the same rights and responsibilities as parents, irrespective of their marital status in matters relating to their children. In this case, the prohibition by the court against a mother impugning the legitimacy of her child is discriminatory, since it is on the basis of the sex of the parents. Specifically, it limits the rights of a mother to do what she thinks is best for her child in order to protect the reputation of the father, regardless of how it may affect the welfare of the child. Thus, to eliminate this discrimination, the CEDAW may be used to claim that whatever rights the father may have regarding their children must also be made available to the mother. The formal source of the CEDAW is the treaty-making process, while the material source is the text of the CEDAW itself. The CEDAW is an international agreement to which the Philippines is bound under international law because it signed it on July 15, 1980, the President ratified it on July 19, 1981, and the instrument of ratification was deposited on August 5, 1981. It was domesticated into the Philippine legal system by ratification pursuant to the Prime Minister's power under Section 15, Article 14 of the amended 1973 Constitution, which states that the Prime Minister may enter into international treaties or agreement as the national welfare and interest may require. Hence, the CEDAW can be considered a treaty rather than a mere executive agreement. Consequently, when domesticated in the Philippine legal system, it has the same level as statutes. Thus, it may fill in the gap in the family code and become a basis to authorize a mother to impugn the legitimacy of her child through an action to impugn legitimacy. That ends my presentation. Thank you very much for listening. And the next presenter is Patricia Jacqueline Ballesteros.
Good morning, everyone, rather. My name is Patricia Jacqueline Ballesteros. So to guide us through my discussion, I would like to give everyone this hypothetical scenario. So, for example, there's person A and person B. They're a same-sex couple, and they're in a loving and long-term committed relationship. They would want to take their relationship to the next level. However, they know that under the current status of our laws, that is not yet possible. Suppose that person A, after coming to terms with his own mortality, because after going through a pandemic, he wants to designate person B with to take care of his funeral arrangements after his die and to bury him at a memorial lot where they both chose. Can person A validly give this right and duty to person B? The Philippine Civil Code provides under Article 305 that the duty and the right to make arrangements for the funeral of a relative shall be in accordance with the order established for support. We see under the Family Code that these persons are a person's spouse, descendants, ascendants, and siblings in that order of priority. We also see under Article 307 that the funeral shall be in accordance with the expressed wishes of the deceased. A plain reading of this provision would suggest that the remedy is already available to person A. However, we see in jurisprudence that this is not the case. The Supreme Court had an opportunity to interpret this provision in 2014 in the case of Valino versus Adriano, where it says that the wishes of the deceased with respect to the funeral are limited by Article 305 in relation to Family Code 199. This means that a deceased has a limited choice on whom he or she can authorize to give such right and duty. Applying this then to our hypothetical scenario, we see that person A cannot validly give that right and duty to person B. And even assuming that person A gave that right and duty to person B, person A's parents, for example, can override that decision and legally claim otherwise. This is the problem that I seek to answer with international law. The International Covenant on Civil and Political Rights states that all people have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. The ICCPR is binding, having been signed in 1966 by the Philippines and ratified by the President in 1986. This treaty has been domesticated in the Philippine legal system through transformation by a treaty. Note, however, that this agreement, unlike other treaties, was not concurred in by the Senate, as is required by the current Constitution or even by the 1973 Constitution. It bears noting that the ratification happened in February 28, 1986, or during the interregnum period. It sits exactly between that period after February 25, 1986, when the government successfully overturned the Marcos government, and March 25, 1986, when the revolutionary government promulgated the Provisional 1986 Freedom Constitution. Therefore, the ratification happened when no constitution bound the revolutionary government, hence the Senate requirement cannot be said to take effect. This agreement has a binding effect of a treaty because it was then ratified by the revolutionary government who at that period in time in our history exercised executive, legislative, and judicial powers. Having established that the ICCPR is binding as a treaty, it stands therefore on the same level as domestic law. Applying this international rule to our problem, I seek a reinterpretation of the Civil Code provision on funeral arrangements. As I have earlier suggested, a plain reading of Article 307 suggests that the remedy is already available. Thus, there is no conflict between the Civil Code as written per se and the ICCPR. The Supreme Court interpretation in Valino versus Adriano is what conflicts with the international law. By taking into consideration the domesticated rule of international law, a decedent may then, by his expressed wishes, authorize even a non-relative with the right and the duty to make one's funeral arrangements, and only when there is ambiguity or doubt as to such expressed wishes should Article 305 of the Civil Code apply. Thank you for your time. May I introduce our next speaker, Ms. Bautista.
Thank you, Ms. Ballesteros. Good morning, I'm Christine Camille M. Bautista, and the case study that I will present is the Convention on the Elimination of All Forms of Discrimination Against Women, or the CEDAW, as a basis to declare unconstitutional the second sentence of Article 225 of the Family Code. So under the said provision, while the spouses shall jointly exercise legal guardianship over the property of their unemancipated child, in case of disagreement, it is the decision of the father that shall prevail. Hence, in a hypothetical case whereby a wife named Jenny Cruz seeks to sell a parcel of land owned by her minor child Angel to secure and ensure payments for her future tuition fees, but Jose, her husband, who is an avid gambler, opposes her so that he can mortgage the property for the debts he incurred in the casino, the husband Jose's decision will automatically prevail and Jenny cannot impose hers without resorting to our courts. The provision thus perpetuates unequal status of the spouses and preserve outdated concepts of patriarchy within the family. In turn, women suffer discrimination in the administration of their children's property, therefore violating the constitutional mandate of the fundamental equality of the sexes. In this case, the wife, Jenny Cruz, to seek relief, can file a case to declare unconstitutional the said Family Code provision for violation of the Constitution as interpreted in light of the CEDAW. The CEDAW, an international law, is binding and applicable in our jurisdiction since the Philippines is a state party thereto. The treaty was signed in 1980 and the President ratified it in 1981. During such period, Article 14, Section 16 of the 1973 Constitution provides an exception to the treaty rule such that the majority concurrence required therein is dispensed with, as the President may enter into international treaties or agreement as the national welfare and interest may require. By virtue of this rule, the CEDAW is thus domesticated by way of transformation, making it part of the Philippine legal system. In this case, the formal source of the CEDAW is the treaty-making process, while the material source is the text of the CEDAW itself. It is on the second tier in the hierarchy of Philippine legal rules, and therefore has the same status as those of a statute. The effect of using CEDAW in this case will result in a reinterpretation of a Philippine rule, particularly Article 2, Section 14 of the Constitution, which provides for the fundamental equality of women and men before the law. Before the domestication of such rule, the constitutional provision is construed to be a mere declaration of state principle, is deemed as not self-executing, and as ruled by the court in the case of Tañada versus Angara, do not embody judicially enforceable rights. The PIL rule, particularly the requirements under Articles 16 and 2 of the CEDAW, can be used as a basis to give new interpretation to the constitutional provision so as to mandate the Philippines to provide for the equal rights of the spouses in terms of the administration of their children's properties. The Philippines, as a state party to the CEDAW, bound itself under Article 16 thereof to take all appropriate measures to eliminate discrimination against women in matters relating to marriage and family relations, and in particular, ensure the same rights and responsibilities of the spouses with regard to guardianship and with respect to the administration of their children's property. Article 2, on the other hand, mandates the state parties to take all appropriate measures to modify and abolish existing laws which constitute discrimination against women. So the mentioned constitutional provision, as reinterpreted by the CEDAW provisions, will then be the basis to strike down as unconstitutional the second sentence of Article 225 of the Family Code. The said reinterpretation of such rule will therefore serve as a compelling force for the state to undertake its positive duty to ensure the equality of women and men before the law, and to take active steps in abolishing laws that are discriminatory towards the latter. To conclude, as Justice Leonen in the case of Alanis versus Court of Appeals stated, patriarchy becomes encoded in our culture when it is normalized. The more it pervades our culture, the more its chances to infect this and the future generation. My case study aims to enforce the state's duty not only to actively modify what it is in its power to modify, but in effect to some extent actively dismantle the existing patriarchy by addressing the culture that supports it. This concludes my discussion on the CEDAW as a basis to declare unconstitutional the second sentence of Article 225 of the Family Code. Thank you very much, and I now invite the next presenter, Ms. Dakel.
Good morning, everyone. I will now begin the presentation of my case study. So legal separation, as opposed to the nullity of marriage, does not dissolve the marriage tie, but it is a proceeding where one of the spouses is found to be at fault, so the marital obligations are severed. Under the Family Code of the Philippines, there are 10 grounds by which a petition for legal separation may prosper. Some of the grounds include repeated physical violence or grossly abusive conduct, drug addiction or habitual alcoholism, sexual infidelity or perversion, and lesbianism or homosexuality. All the other grounds under Article 55 of the said code constitute marital offense which presents a valid basis for a decree for legal separation, except lesbianism or homosexuality. The relief sought in this case is to declare lesbianism or homosexuality under Article 55(6) of the Family Code as invalid grounds for legal separation, since there is no marital offense if the spouse who is homosexual or lesbian fulfills all the duties of a committed parent to their children, as well as a loving and faithful spouse. Thus, Article 55(6) of the Family Code directly discriminates homosexuals and lesbians on the basis of sexual orientation. The Philippines is a party to the International Covenant on Civil and Political Rights, which it signed and ratified on December 19, 1966 and October 23, 1986 respectively. Thus, under the principle of pacta sunt servanda, the Philippines is bound by it and it must perform its obligation under such agreement in good faith. And the ICCPR has been domesticated into the Philippine national legal system by way of transformation under the Treaty Clause of the Constitution. The Philippine President has signed the instrument of ratification of the international agreement on February 28, 1986, and he then transmitted the signed document of ratification to the Philippine Senate for concurrence on October 23, 1986. And the ICCPR entered into force for the Philippines on January 23, 1987. ICCPR, being embodied in a treaty, has the same status as a statutory rule, particularly on the second tier of the hierarchy of rules in the Philippine legal system. And according to the Supreme Court, treaties form part of the law of the land. Thus, discrimination against homosexuals and lesbians is a violation of the enshrined right to equal protection under Article 26 of the ICCPR, which states that all persons are equal before the law and are entitled without any discrimination to the equal protection of the law. In this respect, the law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any grounds, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. In the case of Tunen versus Australia, the Human Rights Committee found that references to sex in Article 26 of the ICCPR include sexual orientation. And in 2019, the United Nations Office of the High Commissioner for Human Rights reaffirmed that these instruments have been interpreted as including discrimination on the basis of sexual orientation, gender identity, and sex characteristics. And under the ICJ statute, judicial decisions and teachings of the most highly qualified publicists of various nations are subsidiary means for the determination of rules of law. And Article 26 of the ICCPR conflicts with Article 55 of the Family Code. However, the conflict between these two provisions cannot be resolved on the basis of the principle of lex superior derogat legi inferiori because they occupy the same tier in the hierarchy of the rules in the Philippine legal system. Thus, the degree of specificity of their respective terms shall be determined. And in this case study, discrimination on the basis of sexual orientation is much more specific and has much more value than having lesbianism and homosexuality as mere grounds for legal separation. And it has been held that domesticated PL rule shall prevail over Philippine legal rule if the terms and provisions are more specific than those of the conflicting statutory rule. Thus, it is my position that ICCPR can be used as a basis to declare lesbianism and homosexuality under Article 55(6) of Family Code as invalid grounds for legal separation. Thank you so much for listening, and I now call on Ms.
Thank you, Marianne. May I invite the presenters to stay in front, and then we'll give you the microphone. So first question is for Antoy. Jay, just stay in front. Can we flash Antoy's screen? Her slide, I mean. So Antoy was invoking CEDAW, right? The Convention on Elimination of All Forms of Discrimination Against Women. And you're using it as authority for a mother to impugn the child's legitimacy, right? Now, if you look at CEDAW, it does not expressly authorize the mother to do that. So how can we interpret CEDAW to support the relief that you seek?
Thank you for the question, sir. To interpret the CEDAW, we can use the provisions in the Vienna Convention on the Law of Treaties, which states that a treaty may be interpreted in good faith in accordance to the ordinary meaning given to its terms in light of its object and purpose. So the CEDAW states that states parties must eliminate discrimination against women by ensuring, on a basis of equality of men and women, the same rights and responsibilities as parents. So interpreting this provision of the CEDAW, given its ordinary meaning, whatever rights, the same rights as parents must be available to both the father and the mother. And since in the Philippines, the father is granted the right to impugn the legitimacy of a child, the CEDAW mandates that this must also be available to the mother.
Okay. Thank you very much, Antoy. Next is for Pat. So Pat invoked the International Covenant on Civil and Political Rights. So can we flash her slide? Yeah, okay. So if you look at ICCPR, so we know ICCPR is broadly worded, no? It's broadly worded. But then you chose a specific provision of ICCPR, Article 1.1, and that refers to the right of a people, no? To self-determination. So number one, your use of ICCPR, which is broadly worded, and then your choice of the specific provisions. They don't seem to support the relief that you're seeking. How can we interpret the provisions of ICCPR to support the relief that you want?
Thank you for that question, sir. As the first sentence provide, all peoples have the right to self-determination. And as I've mentioned earlier, there isn't really a conflict between the Civil Code and this provision in the ICCPR. I want to call back to Article 307. The funeral shall be in accordance with the expressed wishes of the deceased. This is the part of self-determination that I want to invoke. The decedent, of course, prior to him dying, he has the right to determine for himself what happens to his body, to whom it will go to. So that's I hope that answers your question, sir.
Thank you, Pat. For Casey, right? So Casey, you invoked CEDAW also. Next slide. Okay, so CEDAW, if you read here, it obligates the states parties to take all appropriate measures. And I think I heard you say that there's an obligation to repeal discriminatory laws, right?
Yes, sir, in another article.
In a succeeding provision. Huh? So there's an obligation on states that are party to CEDAW, like Philippines, to take all appropriate measures to eliminate discrimination, and this includes the obligation to repeal discriminatory laws. Don't you think that we need Congress to first repeal the family code provision before we can obtain the relief that you seek?
In my case study, rather than resorting to the Congress, what I seek for the wife to do in this case is to file a case to declare unconstitutional the family code provision using the constitutional provision, Article 2, Section 14, but as interpreted in light of the CEDAW provision, so Article 16 and Article 2 of the CEDAW, which ensures the fundamental equality, the equality of the spouses with regards to the guardianship, and also under Article 2, the mandate to the state parties to abolish and, or modify existing discriminatory laws against women.
I'll have a follow-up question because you quoted Alanis, right? The case of Alanis versus Court of Appeals. So in relation to that case, my question would be this obligation to take all appropriate measures. So we know it's imposed on the states, and the states act through their government. Is this obligation not imposed on Congress alone, such that we first need them to act? Why would a court take it upon itself to eliminate discriminatory laws and not wait for Congress first?
Under our constitution, it does not really specify who among the branches will embody the principles as stated in the constitution. So rather, as mentioned, rather than resorting to Congress, my case study seeks to rather resort to our courts and not merely wait to the Congress so as to obtain immediate relief to the claim that I seek to receive in this case.
Okay, because in Alanis, the Supreme Court said that this obligation by the Philippine state is shared by all branches of government, executive, legislative, and also the judicial branch. Okay, thank you. So for Marianne was invoking the ICCPR, right?
Yes, sir.
So ICCPR also, same comment as I gave to Pat, it's broadly worded and it does not expressly authorize the relief that you seek. So you want to declare those grounds invalid, right? So it's not in the ICCPR. How can we interpret ICCPR to say that those two grounds are invalid? And then second, you mentioned a judicial decision, right? That was an Australian judicial decision. Now, can we use a national court decision as a subsidiary means for determining rules of international law? Or are we not supposed to use international court decisions only?
For the first question, the ICCPR could be used to interpret that homosexuality and lesbianism are invalid grounds on the basis that it is discriminatory on the basis of sex, and in relation to that, sex can be also interpreted with in terms of referring to sexual orientation or the emotional attraction of a person to another. So that answers the relief that I'm trying to seek, that having lesbianism and homosexuality as grounds for legal separation is discriminatory because the ICCPR explicitly prohibits it as grounds for discrimination. And for the second question, we can use international decisions, judicial decisions, because under the ICJ statute, it says that we can use judicial decisions as well as the writings of highly publicized from various nations as a basis to interpret these rules. So, thank you, sir.
Thank you very much, Marianne. So we've had 15 presenters already, and we'll hear the presentations of 6 more before we take a break for lunch. No? So I'm now going to introduce our next presenter. He is the beadle of his class, the block 3rd year BGC Day 1. Okay, he is Mr. Jet Nicolas.
Good morning, my name is Jet Nicolas, and COVID is not just one of our health crises that we face today. A long-standing problem that we have is the problem of cigarette smoke and the health crisis associated with smoking cigarettes and those surrounding from the cigarette smoke. And this crisis is propagated and continued because of the constant advertising, promotion, and sponsorship of cigarette manufacturers, or APS, that continues the addiction and new users and further propagates the problem of the health crisis of the smoking pandemic. Transparency in tobacco advertising, promotion, and sponsorship, or TAPS, is important in such a problematic industry. It is common knowledge that cigarette smoke causes many lung-related diseases and further complications, not just to the smoker himself or herself, but also the people who don't smoke and are affected by second-hand or third-hand smoke. Thus, it is equally important to acknowledge the billions of pesos being funneled into advertising these types of products, especially since advertising, promotion, and sponsorship in the Tobacco Regulation Act of 2003 is severely restricted but not completely banned. Therefore, a lot of cigarette manufacturers go into very insidious techniques of taps in order to continue to sell these kinds of products. Last month, when I opened Grab, I got an ad for IQOS, a tobacco product. When I was going to pay with GCash, I also got an ad for a tobacco product. When you go to Shopee, Lazada, you see the same things. When you want to go to a night out and go to a bar, you randomly see logos of Marlboro and other cigarette manufacturers. In the alfresco area, the cigarette containers contain their logos. A lot of these things are very insidious ways that cigarette manufacturers are able to attract and continue to make sure that their brand is still well known in the public. Therefore, we see that this type of advertising, promotion, and sponsorship is a real problem, and that we cannot solve the health crisis propagated by cigarette smoke until we realize the extent of the advertising, promotion, and sponsorship of these cigarette manufacturers. But the problem here is that we don't know the extent of the taps. But the Philippine rules, the Tobacco Regulation Act of 2003, does not have any requirement for the cigarette manufacturers to disclose these types of taps to any government agency. Thus, how will the public know? How will the government know how to actually tackle this public health problem without knowing the extent of the tentacles of the taps in the industry? Thus, my solution and the relief I'm seeking is to use the WHO Framework Convention on Tobacco Control as basis to compel cigarette manufacturers to disclose their advertising, promotion, and sponsorship expenditures to the Department of Health. The WHO FCTC, the Framework Convention on Tobacco Control, is binding in the Philippines because, one, the Philippines signed on September 23, 2003, the FCTC in accordance with Article 34 of the Convention. Second, we actually deposited the instrument of ratification in accordance with Article 35 of the FCTC on June 6, 2005. So this is why it's binding under international law. Subsequently, it's binding for the Philippines because we are a state part of this, and we have subsequently domesticated the FCTC on October 3, 2004 with the ratification of the President, and on April 25, 2005 with the concurrence of the Senate. The status, therefore, because it's a treaty, is that it's the second tier of the Philippine legal system on the same footing as statutes. This has no conflict because it fills in a gap that the local regulations or domestic laws cannot cover. Thus, we could use the FCTC as basis to compel cigarette manufacturers to disclose their taps to the DOH so that we will know the true extent of their expenditures and to be able to solve the health crisis of cigarette smoking and related diseases. Thank you. With that, I call on Ms. Megan Bang-asan for the next presentation.
Thank you, Mr. Nicolas. Good day, everyone. I am Dr. Megan Bang-asan. Breast cancer is the most common cancer among women in the Philippines. The typical cancer treatment can range from 100,000 pesos to 1 million pesos or even more. A diagnosis of cancer is certainly a catastrophe to the finances of most Filipinos. As a response, PhilHealth in 2012 began implementing the Z benefit package that aimed to address breast cancer and other catastrophic illnesses. However, under PhilHealth Circular Number 30, Series of 2012, those who may avail of the Z benefit for breast cancer are limited only to those diagnosed with the early stages of the disease, namely stage 0 to 3A. In other words, a newly diagnosed stage 4 breast cancer patient may not avail of the package for their medical assessment and treatment. While Section 21 of the National Cancer Control Act, or RA 11215, enacted later in 2018, provides for expansion and development of innovative benefits, these are subject to selection criteria that are determined by the DOH and PhilHealth. So why are patients who need treatment such as chemotherapy and surgery the most excluded from these benefits? Since late-stage breast cancer patients are excluded from availing of the package, there is an obvious gap in the Philippine rules from domestic sources. And because Section 25 of the same Cancer Act designates cancer patients as persons with disabilities or PWDs, the United Nations Convention on the Rights of Persons with Disabilities, or the CRPD, may be used as basis to allow late-stage breast cancer patients to avail of PhilHealth Z benefits. Article 25 of the CRPD states, state parties shall provide PWDs with the same range, quality, and standard of free or affordable health care and programs as provided to other persons, provide those health services needed by PWDs specifically because of their disabilities, and prohibit discrimination against PWDs in the provision of health insurance. The Philippines is a state party to the CRPD. The convention was adopted in New York on the 13th of December 2006, signed by the Philippines on the 25th of September 2007 with the instrument of ratification deposited on the 15th of April 2008, and entered into force generally among the state parties on the 3rd of May 2008. The convention has thus been domesticated into the Philippine legal system through transformation, and this makes the CRPD binding on the Philippines with the same standing as executive regulations, procedural rules, and local ordinance in the hierarchy of Philippine legal rules. Article 25 of the CRPD would then fill in the gap in the PhilHealth Circular number 30 by providing late-stage breast cancer patients with the same range, equality, and standard of healthcare as provided to those with earlier stages of the illness. Thank you for your attention. The next speaker is Ms. Isabel Catameo.
Good day, everyone. My name is Isabel Catameo, and the problem I'm seeking to address is the high incidence of minors purchasing electronic cigarettes online because of the gaps in Philippine law. So the relief I'm seeking is ultimately to prohibit the sale of electronic cigarettes to these minors online. It's because these days, I notice that no one actually smokes conventional cigarettes anymore. They're instead vaping or using e-cigarettes, and myself included. But what's alarming about this is that people who actually look younger than me also vape or use e-cigarettes. Well, I would say there are a few reasons for this. First, e-cigarettes are marketed as being safer than conventional cigarettes. It also doesn't smell bad. You don't have to light it. It's heatless. Hence, I would get the appeal for younger people. However, e-cigarettes are still addictive as it contains nicotine, which is what makes conventional cigarettes addicting as well. Moreover, because it's so new, its long-term effects on health still remain to be seen. I, as an adult, perhaps can make more informed choices on using e-cigarettes, but minors are more vulnerable and would suffer more risk if they pick up this possibly dangerous habit. It would then be in our best interest to err on the side of caution and prohibit minors from purchasing these highly addictive e-cigarettes because its dangers are still unknown. So that begs the question then of how are these minors purchasing their e-cigarettes? So a quick perusal of your Shopee and Lazada, which I'm sure you have on your phones, would reveal that there is virtually no barrier for the purchasing of these e-cigarettes because all you need to do is to self-declare your age and date of birth, and it doesn't even ask for any ID or proof of your date of birth. So let's say I'm a highly impressionable 16-year-old, which I look like, and I see someone using an e-cigarette, and I think, oh, that looks so cool. I want to try an e-cigarette. So I'll just go on my Shopee and set my age to 24 with no proof needed, and within 2 to 3 days, I would have my own e-cigarette. So in line with this, we actually have a domestic law that regulates the sale of vapes and e-cigarettes. This is RA 11900. Notably, Section 8 of RA 11900 states that the retailer or distributor of such products shall adopt measures to ensure that persons below 18 years of age are denied access to these products. However, this law seems to contradict itself in that it states that when you buy these products, the person's legal age shall be self-declared. So this means that despite the obligation imposed by the law to prohibit the sale of e-cigarettes to persons below 18, these minors can just easily lie and self-declare their age on their Shopee or Lazada to buy their e-cigarettes. So RA 11900 virtually creates no barrier for minors to purchase their e-cigarettes. So obviously then, there's a huge gap in this domestic law, and this gap can be filled by the WHO FCTC. First of all, we are bound to this treaty because we are a state party. It was also domesticated by transformation when it was ratified by the President in October 2004, and it was concurred in by the Senate in April 2005. Thus, it is on the same level as statute and has become Philippine law. So Article 16 of the FCTC in particular requires that each party adopt and implement effective legislative, executive, administrative, or other measures to prohibit sales of tobacco products to minors. Paragraph 1A of each tobacco purchaser should provide appropriate evidence of having reached full legal age. So remember, legal age. So this would actually create a barrier for minors when purchasing electronic cigarettes because they cannot just simply self-declare their age. They would have to furnish appropriate proof of having reached legal age before they could buy e-cigarettes. So thank you very much for listening. Our next speaker is Mr. Joaquin de Guzman.
Good afternoon. Consider this. Destiny Cigarettes is a new player in the cigarette industry. In order to gain an edge over its more established competitors, Destiny includes more additives to make their cigarettes more appealing, especially to younger smokers. However, research has shown that hydrogen chloride is released by Department of Health versus the Philippine Tobacco Institute. The Supreme Court ruled that tobacco products, due to their harmful effects on health, fall under the regulatory authority of the Food and Drug Administration. The FDA divides the products it exercises jurisdiction over into categories. Each product category is governed by rules that require disclosure of contents before registration. However, no such rule exists for cigarettes. It might be argued that cigarettes should fall under the circular on heated tobacco products. However, the definition of HTPs explicitly excludes cigarettes which are combustible, which mean they burn and are not simply heated. Neither can cigarettes fall under the specific health products category, as this rule requires the listing of pharmaceutical contents, of which cigarettes have none. Admittedly, this gap can be attributed to the tobacco industry's efforts at continually resisting regulation. So, given the gap in Philippine rules from domestic sources, we now turn to international rules. The World Health Organization Framework Convention on Tobacco Control was developed in response to the globalization of the tobacco epidemic. Specifically, under Article 10, cigarette manufacturers have the obligation to disclose product contents, while the government has the right to demand such disclosure. The formal source of such rule of international law is treaty making, while the material source is the text of the treaty itself. The rule of international law is binding upon the Philippine state under the international legal system. Under Articles 35 and 36 of the FCTC, states who have become signatories until before June 29, 2004 can become parties by ratification, while those who have not signed by then can become parties through accession. In the case of the Philippines, we became signatories on September 23, 2003. Then the Philippines deposited the instrument of ratification on June 6, 2005. In turn, the rule has been domesticated into a Philippine legal rule in the Philippine legal system through transformation. The Senate concurred on September 5, 2005 through Senate Resolution 195. As a treaty, it is on the same level as domestic statutes. Turning now to the specific relevant provision, we find that Article 10 can serve as legal basis to require cigarette manufacturers to disclose information on the contents of their products. Clearly, Article 10 fills the gap in the Philippine rules from domestic sources. With Article 10, cigarette manufacturers will need to disclose the ingredients and their percentages to the government for safety and health monitoring. Thus, the government can check what kinds of chemicals are added and ensure that those that increase toxicity, addictiveness, and attractiveness can be controlled. Hopefully, with these safeguards, casualties, such as Elena, can be further avoided and ultimately more lives saved. Thank you. Introducing now Mr. Garcia for the next presentation.
Thank you, Mr. De Guzman. Good morning, everyone. I am Crispin Garcia. The Philippine problem that I have identified is that blind people cannot easily identify the medicines that they buy. With this, my case study explores on how Article 9.2 and Article 21 of the United Nations Convention on the Rights of Persons with Disabilities, or UNCRPD, can be used as a basis to compel pharmaceutical companies to use Braille on their medicinal products. There are three main reasons as to why I chose this case study. First, relevance. Second, convenience. And third, safety. First is relevance. As we all know, we are still in the midst of the COVID-19 pandemic. Whenever a person tests positive for COVID, he would be forced to isolate himself from the rest. This means that he would be temporarily isolated from the outside world, and when it comes to buying medicines, he would have a hard time buying it without assistance from others. And this is where my second reason comes in, which is convenience. If it is already hard for an isolated, abled person to buy medicine alone when he's isolated, it is even way harder for a blind person to buy medicine alone. However, with the proposed mandatory use of Braille on medicine, this problem would be addressed. And for the third reason is safety. If there would be Braille in medicinal products, blind people can easily identify the medicines without assistance from other people. And long-term speaking, this eliminates the threat of taking up the wrong medicine, as the Braille would serve as an additional safety net and source of information for the blind person. In the Philippines, there are already laws that safeguard the interest of persons with disabilities, and one of which is Republic Act 7277, which is the Magna Carta for disabled persons. And the relevant provision for my case is Section 20B, which provides that the national government shall provide an integrated health service for disabled persons, which shall include medical treatment and rehabilitation. However, as we can see, there is a gap in this act, as it does not expressly define nor expound the concept of what an integrated health service and medical treatment are. Because of this, there is currently no incentive nor reason for pharmaceutical companies to use Braille on their products. Fortunately, UNCRPD provides basis for this. Article 9.2 states that states parties shall also undertake appropriate measures to promote appropriate forms of assistance and support to persons with disabilities to ensure their access to information, while Article 21 states that states parties shall take appropriate measures to ensure that PWDs can receive and impart information on an equal basis with others and through all forms of communication of their choice. This UNCRPD is an international law that was adopted by the UN General Assembly last December 2006. It is a binding international agreement in the form of an executive agreement that creates obligation for its parties. And this was converted into Philippine law through the ratification of the President last April 2008 and was entered into force last May 2008. And given that it is an executive agreement, it would fall under the third tier of the hierarchy of the Philippine legal system without any conflict with any Philippine law. And as such, the gap in RA 7277 can be filled, and thus there is basis to compel pharmaceutical companies to use Braille on their products by having Articles 9.2 and 21 of the UNCRPD, which is a domesticated law, to fill this gap in the Philippine legal system. Thank you, and I now give the floor to Mr. Mozo.
Good morning, everyone. My domestic problem is that extradition during COVID exposes extraditees to death in a foreign country. The facts are, a 65-year-old Filipino woman who has diabetes and heart problems committed tax evasion in the United States. She fled to the Philippines, and the United States government is now seeking her extradition through the Philippine Department of Foreign Affairs. Because of her advanced age and comorbidities, the accused is afraid that she will contract COVID and die in the United States, which is one of the highest COVID infection and mortality rates in the world. She claims that this would be tantamount to imposing the death penalty for an offense punishable only by imprisonment of 5 years. PD 1069, otherwise known as the Philippine Extradition Law, does not provide for the suspension of extradition on the ground of health risks such as the COVID pandemic. The extradition process begins first when the requesting state, through its foreign diplomat, files a request addressed to the Philippine Secretary of Foreign Affairs. The Secretary of Foreign Affairs shall forward this request together with the related documents to the Secretary of Justice, who shall immediately designate and authorize an attorney in his office to take charge of the case if the request meets the requirements of the extradition law and the relevant bilateral extradition treaty. Thereafter, the attorney so designated shall file a written petition with the proper regional trial court which has jurisdiction, together with a prayer that the court shall take the request under consideration and shall attach to the petition all of the related documents. And then upon the receipt of the petition, the judge of the court shall summon the respondent to appear and answer the petition. The respondent should file her comment to the petition, setting forth the reasons why she should not be extradited. There shall then be a public hearing, and there are only two things that the judge can do: either grant the petition or dismiss it. If the petition is granted, the accused shall have 10 days, or the respondent rather, shall have 10 days from receipt of the decision of the RTC to appeal to the Court of Appeals. And lastly is the surrender of the respondent to the requesting state. The relief sought would be to prohibit the DFA from evaluating a request for extradition during the COVID-19 pandemic. Because the domestic problem is that extradition during COVID exposes extraditees to death in a foreign country, I am invoking the international rule of the International Covenant on Economic, Social, and Cultural Rights. Article 12, Paragraph 1, which states that the states parties to the present covenant recognize the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. Because the Philippines recognizes the right to health of the respondent, the DFA should be prohibited from evaluating a request for extradition during the COVID-19 pandemic, a precarious time for the health of every individual. This international covenant was signed by the Philippines, particularly its ambassador, on December 16, 1966. It was then ratified by the former President Marcos on May 17, 1974, and it entered into force on January 3, 1976. The Philippines is bound by it because it is a party to the international agreement, and it was domesticated through transformation, because former President Marcos, having both legislative powers and executive powers, entered into it as the national welfare and interest required pursuant to the 1973 Constitution. This rule of international law is on the same level as a statute because it was ratified by the President pursuant to his executive and legislative powers at the time. And lastly, this international agreement fills a gap in Philippine rules from domestic sources, and there's no conflict to be resolved. Thank you everyone for listening, and the next speaker is Sani Usodan.
Good morning, everyone. For my case study, I will be presenting how customary international law can be used as basis to authorize a wife to testify against her husband in a criminal case for a crime committed by the husband against his own direct descendants or ascendants. Let us take a hypothetical situation where husband Edgar and wife Beatriz are spouses. Husband Edgar also has a child in a former marriage, and that child is Alan. During the existence of their marriage, husband Edgar killed his own child, Alan, or his own direct descendant. In that case, following the provisions of the rules of court, wife Beatriz cannot testify against husband Edgar in a criminal proceeding without the consent of husband Edgar, who is the offender's spouse. This is the Philippine problem that we intend to resolve. This is because in the Philippines, our legal system advocates in preserving the marital harmony between married individuals. To prevent the witness spouse from being placed in a cruel dilemma, that is, whether to testify or not against the offender's spouse, our legal system adopts the marital disqualification rule. Particularly, under Rule 130, Section 23 of the Rules of Court, it states that during their marriage, the husband or the wife cannot testify against the other without the consent of the affected spouse. There are, however, exceptions provided under the said rule, and these exceptions are, number one, in a civil case by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. In our example, if the crime was committed by husband Edgar against the children or the parents of wife Beatriz, she can then testify against her husband pursuant to the said exception. Our example, however, is different in such a way that the crime was committed by husband Edgar against his own child in a former marriage or his own direct descendant. The rules of court dictates that wife Beatriz cannot testify against husband Edgar without his consent. With this, it is therefore my contention to include an additional exception to the said rule by allowing wife Beatriz to testify against husband Edgar for the proper administration and attainment of justice. This is pursuant to the customary international law as reflected in the Universal Declaration of Human Rights. Particularly, Article 8 states that everyone has the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights granted him by the Constitution or by law. Under this rule, the right to an effective remedy encompasses an obligation to bring to justice perpetrators of human rights abuses. and also to provide appropriate reparation to victims. Reparation can involve measures including rehabilitation, guarantees of non-repetition, and changes in relevant laws and practices. As a customary international law, the rule is binding through the general and consistent practice of states, and the Philippines is not a persistent objector. The rule is domesticated through the incorporation clause under the 1987 Constitution, particularly under Article 2, Section 2, which states that the Philippines adopts the generally accepted principles of international law as part of the law of the land. As a result, the domesticated pill rule forms part of the Philippine legal system and is considered to be of the same level as a statute in the Philippines. In effect, the domesticated pill rule will result into a reinterpretation of the relevant Philippine rule from domestic source. This will enable us to revisit the purpose of the marital disqualification rule and harmonize it with that of the domesticated pill rule. In the interest of justice, the domesticated pill rule can then be used as basis to include an additional exception by allowing a spouse to testify against the offender's spouse for the crime committed by the latter against his own direct descendants or direct ascendants, most especially if the testimony of the witness spouse will advance the cause of the victims of human rights violations and is material for the resolution of the case. Therefore, in our hypothetical situation, the domesticated pill rule may be invoked to authorize wife Beatriz to testify against her husband Edgar for the crime committed by Edgar against his own child Alan. That ends my presentation. Thank you.
Okay, thank you, Sani. Before we take our break for lunch, let's ask the presenters a few questions. Can we ask them to come up front? And then we'll share with you the microphone. So first to Jet. Okay, can we flash your screen, your slide? Okay, so to Jet, so FCTC, and you talked about the obligation on cigarette manufacturers to make the disclosure, right? Now, if you look at the provision of the international agreement that you want to use, it obligates each state party, including the Philippines, to require disclosure in accordance with its constitution or constitutional principles. And also, in the last line, there's a reference to national law. Doesn't this mean that the FCTC is not self-executing and therefore we need Congress to first enact a statute requiring disclosure before we can require the manufacturers to disclose?
Thank you for the question, sir. I'll answer the question in two levels. So on the first level, I disagree that it is not self-executing. So it is self-executing. So if you look at the wording in paragraph 4, sir, it says as a minimum, and then in each party shall, and then in subparagraph D, it says require if it does not have a comprehensive ban. So just using the words as a minimum and require, and if you give the ordinary meaning to the words, and if you look at the Vienna Conventional Law of Treaties, Article 31, paragraph 1, we should give the ordinary meaning to the words. And the ordinary meaning as a minimum and require, it imposes a mandatory effect that it is a duty for the state or an obligation for the state to do this. And this is even apt for the Philippines because RA 9211 does not have a comprehensive ban on tobacco advertising promotion and sponsorship. So the subparagraph D is applicable because we do not have a comprehensive ban. So we must require a disclosure to relevant governmental agencies. So on the first level, I think that it is on the ordinary meaning, it is mandatory. And as a side, the subject to national law is about a different sentence. So there's a second sentence. Those authorities may decide to make those figures available. So the duty to disclose is separate from the option for the authorities to make the figures available. So the subject to national law does not affect the duty or the obligation rather to require the disclosure. On the second level, as you mentioned, sir, a while ago, you said Alanis versus Court of Appeals. Not just Alanis versus CA, penned by Justice Leonen, which stated that courts are just like other governmental departments, but even in Department of Health versus Philippine Tobacco Institute, citing David versus Senate Electoral Tribunal, which stated that the whole of government, including the judiciary, has the duty to comply with international obligations of a treaty under the principle of pacta sunt servanda. So we don't need the Congress to pass a statute because filing in the court in itself, the court is required to comply with FCTC to require disclosure. So the court can, on its order, compel cigarette manufacturers to report their taps to the DOH because the court is bound by the treaty as well as part of the state.
Okay, thank you. So we have 2, 4, 6 more, and then 7 minutes before we take our lunch break. So we'll cut it down to maybe a minute for each presenter, no? So for Meg, CRPD obligates each state party to provide PWDs with the same range, quality, and standard of free or affordable healthcare and programs as provided to other persons. Doesn't this mean that if the Philippines does not give good health benefits to non-PWDs, then PWDs cannot demand special treatment?
Sir, and the next provision, sir, the CRPD also requires state parties not just to also give health services needed by PWD specifically because of their disabilities. So it is already from that international rule, sir, the state parties are already mandated to give benefits to PWDs. So there is no reason in my argument for higher stage cancer patients to not be able to be given the benefits that are given to earlier stages.
Okay, thank you. Then to who's next? ESA. So ESA, FCTC requires each party to adopt effective measures. And then it says, there's a word there, each party shall adopt effective measures. These measures may include, it does not say shall, it may include requiring sellers to require purchasers to show proof of age. Does this mean that Philippines has no duty to require tobacco sellers to require buyers to show proof of age?
Thank you for that question, sir. So to clarify, the FCTC requires that each party shall adopt and implement statutes or other rules to prohibit the sales of tobacco products. So this means that there is a positive obligation in the state to implement such statutes or rules to prohibit the sales of such products to minors. So I submit that while the FCTC states that the state may require tobacco sellers to require buyers to show proof of age, meaning it is not required, practically speaking, requiring proof of having reached legal age would be the most efficient and effective barrier to prohibit the sale of electronic cigarettes online. Furthermore, this would fill the gap of RA 11900 in that the self-declaration of one's age would be replaced by the showing of actual and concrete proof of having reached full legal age in accordance with our positive obligation to prohibit the sales of such products to minors.
Okay, thank you very much. Next to Joaquin, who just came from class. So FCTC also, right? So it says here that each party may adopt measures to require disclosure, right? But then it says, in accordance with its national law. Very similar to what I asked Jet. It seems to suggest that the FCT is not self-executing. Do you agree?
Sir, similar to Jet's answer, I disagree that the FCTC in this case is not self-executing because, first of all, when we look at in accordance to national law, as I pointed out earlier, national law already requires the disclosure of all the other products. But there's a missing gap for tobacco products. And then for cigarettes specifically, So the gap that needs to be filled is simply to enable to the administrative agency or the FDA needs to do is simply to put out a list of what needs to be required for tobacco for cigarette manufacturers to disclose. However, the disclosure is already required by the law by the treaty itself. Thank you, sir.
Okay, thank you. Ano ba to? Yung? How do you pronounce it? Jung? Kasi pag German, yung to, di ba? Yung. Jung. Okay, so if the court grants your relief, the pharmaceutical companies will have to spend a lot of money, right, to comply with the order. So we have to make sure that CRPD really requires pharma companies to use Braille, as you say. Now, if you look at CRPD, it does not expressly require pharma companies to use Braille. So how can we interpret CRPD to support the relief that you want?
Thank you for that question, sir. I'm aware that it is not explicitly mentioned in UNCRPD that Braille must be used. However, I would like to emphasize what is stated in Article 21, which states that the state parties shall take appropriate measures to ensure that PWDs can receive and impart information through all forms of communication of their choice. And applying this to the relief that I am seeking, it is important to note that Braille is one of the forms of communication of choice for blind people, for them to actually have access to information that they are reading. And with that said, I believe that it could be used as basis to compel pharmaceutical companies to actually use Braille on their medicinal products.
Okay, thank you very much. Now to Migs. So Migs is invoking the International Covenant on Economic, Social, and Cultural Rights. And as we know, if you read ICESCR, it's broadly worded. And also, I think I pointed your attention to Article 2, right? And Article 2 of ICESCR softens the obligations. If you read the rest of ICESCR, they seem to provide for hard obligations. But then, all of these hard obligations are softened by Article 2. Why? Because Article 2 requires parties to perform their obligations only to the maximum of their resources. Sort of like a best efforts basis only. No? And also, it mandates that the ICESCR rights be fulfilled progressively over a period of time, not immediately. So they seem to soften these seemingly hard obligations in ICESCR. Does this mean that ICESCR provides only soft obligations and cannot create a duty on the part of DFA to stop the evaluation of an extradition request during COVID?
Thank you for the question, sir. I would say no, sir, because the Philippines has the capacity to perform its obligations under the international agreement. So even if there's a provision which softens that duty, the Philippines is more than capable of performing it. And secondly, even if the provision is broad, a broad provision is construed in a way that includes all situations in which the health of a person could be protected. And that's why I contend that my remedy or relief falls under this provision.
Okay, thank you very much. So it's now 12:01. So Sani, you have to be very short, brief in your answer. Because people must be hungry by now. Okay, so the question to you is, in your case study, you used customary international law, right? As
Yes, sir.
reflected in the Universal Declaration of Human Rights. So that's the non-binding instrument that you're using, and you're using it as evidence of the content of the binding unwritten customary rules.
Yes, sir.
Now, if you read the provisions of UDHR, here, Article 8, everyone has a right to an effective remedy. It seems to be broadly worded. It doesn't specify that the wife is authorized to testify against the husband, right? How can you now apply the unwritten rule or interpret the Article 8 of the non-binding instrument to justify the relief that you seek?
Thank you for that question, sir. In Article 8, the right to an effective remedy, it encompasses an obligation to bring to justice perpetrators of human rights abuses. And one way of bringing to justice these perpetrators is by allowing a witness spouse in our example, to testify against the offender's spouse, most especially if that witness spouse is material to the resolution of the case. Thereby, if you're going to allow the material witness spouse to testify, then that can be a way of bringing to justice the perpetrator of a human rights violation.
Okay, thank you for that brief answer. So now we come to the end of session 2, right? This is session 2. Congratulations to the first batch of presenters. We'll take a short lunch break. I think there's food available for everyone. And so we'll resume at 1 p.m. Thank you very much. See you later at 1.